small and tight. Did not let you. Sarah's laugh rings through the night. Such a brute, drunk and silly, thought she'd play. Crazy witch, let me in just for the day. Life's a bitch. Can't you hear me, Sarah, please? Hook ass bitch, out of there my lungs they squeeze. Let me out, you witch, this is not a funny joke. You put your hands around my throat, feeling trapped and nearly choke. Gonna croak. Can't you hear me, Sarah, please? Hook ass bitch, out of there my lungs they squeeze. Let me out, you witch, this is not a funny joke. You put your hands around my throat, feeling trapped and nearly choke. Gonna croak. Sarah, let me out, I'm begging, please. Stop, I'm almost begging, please. Please, someone don't leave me here. Lost my hair, in this case I disappear. Are you there? Dark and tight, I curl and wait. Are you passed out? You'd return my fate. You empty my stash out. The game has turned to cruel. Why are you filming late? Inside I feel the fool. I can't breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as her castaway. Sarah, let me out, I'm begging, please. This stuff I'm almost begging, please. Please, someone don't leave me here. Lost my hair, in this case I disappear. Are you there? Boom! Looking tight, I curl and wait. Are you passed out? Hoping you return my fate. Empty my stash out. Stupid game has turned to cruel. Why are you feeling me? Lost inside, I feel the fool. I can breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. Breathing stuff, I'm almost begging. Please. Drink so don't leave me here. Lost my air in this case I disappear. Are you there? Sarah, oh, 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 Sarah, oh.
Good evening, everybody. We are about ready to fire this bad boy off. I hope you're doing well tonight. Oh my God, today was fire just when you thought there couldn't be more or wouldn't be more. Good Lord, those videos were bad. Oh yeah, it gets insane. I am telling you, the amount of insanity there is. If she's not found guilty and given jail time to serve a minimum of 50 years, I'll be shocked. Hey, if her defense could actually get their head out of their ass and stop delaying shit, they could have had this crap finished today. Insane, huh? Yeah, I know. I understand insane. It is crazy. Beware of the prowling trolls. I'm not really worried about them. They've got better things to do than this piddly ass little channel. And if they do, well, we have ways of handling some silly little fools. We have our ways. Just let's put it that way. It's awesome. Oh, I love it whenever I put these things in here, and they give me a add suitability whenever I tell them exactly what this is going to be about. I don't understand why they don't understand this. They hit Baker and Moe today. Yeah, like I said, I'm a nobody. They've got no reason to come after me, you know. And if they do, well, they like I said, we have a vase. they would be amiss. They would be amiss to do that. Yeah, the vids at the end where it's so bad it triggered your resident optimist at heart. Yeah. Yeah. You know, I did see a little bit of those. I was working most of the day, so you get to enjoy this stuff all over again with me. Isn't that awesome? Let's see what they've got today. Oh, Lord Almighty. Hopefully I got my audio.
Sarah Boone, and I'm today for the record
Helps if I
against the
turn off
state.
the
Chief
mute.
Castro on behalf of the state, William J. for the state.
Defense,
James Owens for Sarah Boone.
You can stay as
Tell
long
me
as you
Anderson
like.
for Sarah. Have it back.
It's too close to
Ms.
home.
Boone,
Sorry
raise
to
your
hear
right
that,
hand,
Pam
please
Graham.
swear. Please, do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated
Hey.
at counsel's table,
Does.
buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel? Defense, anything we need to
Get out
address?
of this for a little bit.
Mr. Judge, I intend to introduce
There we go.
these two exhibits that have already been situated to. One is
I like that one. Just until it goes away.
What's their name?
Right now, their ID is A, Z, as in boy, and E, C, as in.
Defense identification AB judge, which is the order. The June 16th, 2019, it's a no contact order. And then identification. AC,
Yeah, we knew these were going to be coming in. The no contact orders.
so it is a
We can
No contact
fast forward
order.
through a lot of this.
dated June 19th, 2019.
So just be advised, we'll use our time. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those,
Okay.
the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am.
Just out of abundance of caution, I would renew our motion for judgment of acquittal, pursuant to defense.
That's the
resting.
case.
I'm going to go do that now on jury.
Yes, I'm hiding behind the
I
bar.
don't have any additional arguments.
It's okay.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could.
Well, you have to understand they don't have to disprove anything. All they have to prove is that this was self-defense. That's all. The only thing that they have to prove. See, that's the crux of it. Is they never prove self-defense. They're expecting somebody else to do that for them. Owens has got to have a red face after Judge smacked his. Well, we'll get to that.
Find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you.
Yeah, there
The
is.
court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your
Actually, yes, it could be self-defense, even if they battered each other, because all of those prior acts don't matter up until the point that somebody loses their life. None of those prior acts matter. The way that works is, at what point is it self-defense? The point is whenever you're under threat of imminent harm. Imminent means that somebody is standing in front of you, has a weapon drawn on you, or they're going to strike you. Then all of the other stuff comes in play. They're taking a swing at you and you delete them. Locking them in a suitcase for 20 minutes is not imminent harm. So that's all there is to it. She can claim self-defense, but she has not proven that. That's the problem. She has to prove self-defense. So that's why she's having a hard time.
Attorney has indicated that all of the evidence
No
and
problem.
testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back
I
in,
think I
he
can
will
speed
enter
this
into
up a little
evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No,
Is there any evidence that you wanted your attorney to present that any of them failed to present?
no,
Are you satisfied with all of your attorneys up and until this point?
very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right.
Well, I've got this
Um,
little itch,
I did receive
Judge.
the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, because did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night.
Yep.
Once we got out of court, I'll send them to everyone this morning. Just give me a moment, and I'll get those out right now.
And there will be lots of skips in here because, oh my God, the amount of skips that I need to put
Is there
in
anyone
here
else?
because
The email correspondence that I have
the
is Mr. Owens'
city.
email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that may need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good.
Owens would make a horrible poker player.
All right, can we go ahead and bring in our panel, State?
You're welcome.
Yes, sir.
You're welcome,
Defense?
Sammy.
Yes.
All right, let's stand and bring in our panel, please.
I try to make it a little bit easy. Try to have some humor and not be stressing out about it. You know, it's a tough situation. I mean, Owens, I'm sure, is a pretty good attorney. He's just got a bad case. That's all. Oh, well, you haven't seen too many attorneys because they do it all the time. They do it all the time.
Jury's entering.
There's a lot of jury entering and jury exiting. Oof. There will be on this one. I think people are going to start getting low. The jurors are probably not happy about it.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury.
Yes, I did.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
Oh, a little. Yeah, this should have been done at noon.
But at this time,
So this all of this crap should have been done at noon. The jury box was a trampoline. Yes, it was. No, this physically should have been done at noon, but Owens had to go and just all he was doing was wasting time. So, and I think the prosecution played it very well. I think they played it very well because they held on to those last videos until the end of the day today. Okay. Now, you may have not seen a whole lot of this, which is understandable. Or maybe you have seen it, so don't give too much away. But one thing I want you to note is how much of a delay that he puts on it, where it ends up delaying it until after lunch. What he was hoping is that they would finish up with their rebuttal with that with the last person, and then they would be giving their closing arguments and hoping that the defense would be able to give their closing remarks at the very beginning of tomorrow. That's what they were hoping for. because nothing like having a jury come in, and I'm not going to give a whole lot away, Puddletown. Nothing like having a jury fresh, wide awake, and you plead your case in front of them, and then they're sent for the day to go think about it. It does give you a little bit of a leg up. At the end of the day, they're a little bit tired. They're probably just like, ugh, don't want to be here anymore. And then, of course, the prosecution, if they would have not had that extra bit of evidence, I think that was just to ride out the clock until the end of the day. That's my opinion. I'm sticking by it.
I would move to introduce defense identification exhibit AB to evidence.
No objection, AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
At this time, I would like to move defense identification AC to evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
For our protection there, folks. I was working for Super Chat money. That's right. Me too.
And Judge, I would like to publish these to the jury and allow them to take the time and pass these down to.
You may proceed for Super Chat money.
The first is defense exhibit 19. Just review it and pass it in.
So what he's showing them is these basically TROs, which are temporary restraining orders against George. That's what he's showing right now. Yes, Zach is a bad influence with the super chats. Why wouldn't I be? I'm always working. All the time. Like a madman. You'd be surprised what a 100-pound person can do. You would be surprised. Yeah, right now they're just passing notes around, seeing who feels it. Oh.
Thank you, members of the jury. Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
Those are on behalf of Sarah Boone, the defense rep.
Thank you. Defense or state, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Faithful Dr. Tanya Warner.
Oh, Lord. Enough with the tip tapping. All right, here we go. I don't need to know her
When did you
CV.
begin your work as a forensic psychologist in the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress
Here's
disorder.
a shit show commences.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized.
Yeah, she gives just definitions.
Whether there's trauma present or not? Is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
There we go.
Can you describe that?
So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up and the individual can feel kind of the incident coming. And then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds. So they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience,
Well, you do have an invite,
strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case,
Why am I
we
gonna
asked
teach you
to
from
do an
Charlie Brown?
evaluation
It
of
happens.
Sarah Boone.
Hey,
Yes.
JD.
You see Ms. Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
All right, let's get this bad boy fired.
What
Here it
date did
comes.
you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours.
2.5 hours.
I
Good
introduced
Lord.
myself and explained that the interview would not be confidential, that I would be
That's good.
coming to court if asked to
That's cool,
share my
brother.
opinions.
You worked on that.
And she agreed to participate. I then start out with just general information. So getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Can I stop you there? Now, I have to stop Yamaha here. He's eating and working on a leather project that's kind of time sensitive. He's working on leather for this Halloween. I know what he's doing. He's getting out the whip and the leather chaps. He's working on a leather project. Doesn't have time for me. I understand. I see how you are. My heart's broken. Not really, but it's fun to say. I love it. I love it. You go Yamaha. You get it.
Elaborate further on that.
So a mental status examination is just questions
chaps
to
for
determine kind of
alcoholic,
memory
yep.
and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
Go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right. What did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes? Just
If you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
Refresh your memory, just put
Yes.
them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on the human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain. It allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse.
I got to bring this up. All chaps are assless. All of them.
It's now been combined in the DSM-5. In the DSM-5-TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're giving?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Agreed, Stacy.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication
everything
and
today.
battered spouse?
Get with it, Puddletown.
It can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Yeah.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5-TR or battered spouse syndrome.
Yes.
In this particular case,
I'm going to shrink for a minute.
Did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
What was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
and specifically talking about
Yes. Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting
And
for us to
here we
figure out what
go.
we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things. We'll bring you back in as promptly as possible. Thank you.
And here's where shit goes awry. Oh, Lord Almighty. Shit's going crazy.
Y'all can be seated.
This is where Owens
Mr. Owens,
wastes
if you can
time.
find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's.
Now, just a note to all you guys. This right here was about a 4-hour portion before lunch. So you went from 9, 10, 11, 12, about 3.5 hours. I cut it down to 2, less than 2. How's it going, Valor Motorsports? Good to see you. Good to see you. Glad you could make it in. I cut this thing down because there was so many gaps because they were at the bench in front of the judge for a good part of time while they were trying. Owens was trying to argue this shit. Finally, he just called the jury out and said, "We're just going to have a Richardson hearing." He's like, "Done with it. Let's do it."
Deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder and that she was not sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail.
Mm-hmm.
And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits and that those were my 2 major diagnoses. And then I questioned her further.
Just want to point that out right there.
She explained again on line 17 about general anxiety disorder versus the adjustment disorder.
So you guys,
And that I hadn't had
it's
time
probably
to fully
the most
formulate that
interesting thing
opinion.
to see.
Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38.
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process on my notes.
Not my
And
problem.
I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So
Yep,
we could
she does.
discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery
I
after the
wanna
jury
make
trial
fart
starts is
noises on
completely
her calves.
unacceptable to me. So that's my position.
Just get up
If she
there.
needs to issue a supplemental
on her
report, or
calves.
if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once a jury is sworn in jeopardy attachment.
Yeah, nice shoes.
And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out, that she may have other
Sorry to hear
opinions
this, CJ.
and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward. And then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a
Your
report.
svelte legs.
B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning. which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that Mr. J upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41.
You just skipped
that
a
addresses
very important
specifically
part.
opinions as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been
Well, get
previously
your own damn
diagnosed with
expert.
generalized anxiety disorder. And so the Dr. Werner was considering that admission. But she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. Jason, on 22. Okay, so on this topic,
miss
something new
anything.
comes up. And we can
Owens
address
is grasping
But
at
if you have
straws
other
right now.
topics to pose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that you may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, that's how she answered. She goes through a little bit of that. And then
You need to.
paraphrasing, she talks about.
So are you reading the whole
grandiose
deposition for everybody?
component of criteria that she met.
Wasting
And then on page
time.
45, I asked her what other criteria, line 1, which tend to indicate that she was a narcissist.
The judge at any point, he can say, what is your point? I mean, you're reading the deposition for me. I have the deposition right here in front of me. Point to me the issue. The judge is about done. Judge is about done with his bullshit, but he lets it go on.
And the answer, Dr. Werner, I didn't say that she was. I said that she has narcissistic traits, and that was the examples.
Judge, excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism.
Boom.
The question pertains to PTSD.
All right, page 46, line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder?
We're going to go through all 400
Line 3,
pages.
answer.
Oh,
She didn't
judge
give
is
any
not
criteria
happy right
with
now.
regards to that. She discussed having fear and anxiety of his family and feared that they would come into the jail or have someone else come to the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question.
Oh, they're always
13,
popular,
line
Valor.
13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future,
think
give
so,
an opinion
Paul Tan.
about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay.
Oh,
And
come
that's
on.
something you will let the lawyers know about if that changes. Answer, line 2 of page
Defense
47,
and the
yes.
judge are just like, they're sick of this guy.
That's specific
What's
to
your
the
point?
post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that
You
had already
have
told
to
me it's
give
not gonna
him-
continue, I would refuse to take that deposition.
Wrong.
But under the promises from the state.
What
I
are the
will be
legal,
notified of
what are the
any
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second.
Oh, good God.
That's
So
the
nothing.
only thing I know to object
You're
to,
wasting the court's
because I was
time.
not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a
That's
definitive
not
no.
the attorney's fault.
I'm not casting blame. I'm just going back over what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not, it was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
It's no big deal.
Thank you, Puddletown. Appreciate you, brother. Good grief. That's funny. See me two opened up down the street. Oh, yes.
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition.
Diagnoses have not changed.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing. Yes, doctor? Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge,
That's it.
number one, she's given a legal opinion. Number two, it's a discovery.
That's
violation.
not a legal opinion.
What is
That's
the
not a
legal
legal
opinion?
opinion. Yeah.
The post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would
Yeah.
like to have known that, and that was going to be her opinion before today.
It's always been her opinion.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No.
What?
This
No.
is
No.
a 87-page transcript.
Jesus.
You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it. It's
Yeah,
fine.
you've got the burden
Where I
on
asked-
you. You've got this objection.
I mean, this isn't the
Show
first
me-
time I've
show
looked at
me
this
something in
deposition.
law.
The state provided it to me when we had the hearing
Lord, did you?
on whether or not battered spouse would be permitted. The state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which is the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20.
Oh, Jesus Christ, man. It is just like he's grasping at straws playing pixie sticks. It's just like, what the hell is that without the chaps on?
20. Let me know when you're there, Judge.
Hang on.
Yeah.
Yes, sir.
He's got nothing.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
Yeah. How's that changed? In other words, it hasn't.
I believe it's a discovery violation because I should have been notified that there was going to be a change in.
Oh, it's my pussy hurts.
And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial.
You're not ambushed. You're just
What
an idiot.
new opinions
Yeah.
are
What new
different
opinion?
based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk,
it's been
or Madam
so
Clerk,
long.
Are you able to reread the portion of the proffer as to
Because you got nothing.
what Mr. J asked of the witness? Court's going to step off for a moment while Madam
Yeah.
Court Reporter is able to provide that read.
And they had a break. Right here, they had a
All
break.
right, we're back on the
It's back.
record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State,
Dave Castro on behalf of the state. William J. for the state.
defense.
James Owens, Ms. Boone.
Ms. Boone is seated at council's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
Evil hush tones. I have done nothing. Innocent. Innocent, I tell you. Just go back to making your leather
Hi,
chaps.
Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident that she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
That's it.
I don't think that's the very beginning before I objected.
Yes, it was.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response.
Then you should have asked that. The judge offered the proffer. Oh, idiot.
My objection to it.
What was specifically asked was to the proffer, because the question before the
Yes.
court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply.
Where?
In her
Where at?
opinion, that was not
Where at?
discussed in any way in the deposition.
Okay. My question is specific as to opinions.
Yes.
Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is
See, right now he's scrambling and he's it seems like he's disjointed and stuff, but he's very well aware of this witness, what their testimony was going to be. He knew exactly what it was going to be. He objected before she even got the words out of her mouth, before he even finished the question. This was his plan. He picked out one particular spot to waste time. He knew that this wasn't going to be a big deal. He could waste as much time as he wanted to, knew that he would get a Richardson hearing, that he would be sitting there going and arguing all this same stuff and reading through shit that he doesn't need to be reading through. This is intentional. This is a waste of the court's time. And if the judge catches wind of him pulling this shit, the judge will sanction him for it.
was not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
Probably. Really, dude? Wasting time. Yep. Just flip through some pages. Make it look like I'm doing something. Such in a mood.
I think I'd refer to page 46, line 13 of the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47.
Judge is about done with shit.
Yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress.
No, it's not.
In the proffer?
Excuse me?
In the proffer?
In the proffer?
She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now,
They're
the
just looking
proffer
at this guy
is
like,
that
what are
they're
you
claiming that
rambling
post-traumatic
about?
stress does not apply. I don't know what the initial question was, but we haven't had that read back. When it was first going on, when the question was asked, and I believe she rendered an opinion. And I, again, like that, we read back. What the initial question was, what the response was, because it didn't, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach.
Can't remember now.
And then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer if BSS or PTSD hasn't? Can you reread that?
Let's just reread the entire proffer. just so that it's clear, soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind.
Go ahead, sir.
Yes, ma'am.
I feel bad for this court reporter.
Mr. James, question. You've been credited for all
Quit
this
after
hearing.
this.
Yes, doctor. Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your
Well, you would think that, but that's not what he's doing right now. Right now, he's wasting time. And this is my opinion, okay? My opinion is he's wasting time because he's hoping that if he delays enough time, that the defense will rest after lunch. That they'll rest their case and then they'll go into closing arguments. The longer he delays, that means that they get a fresh day on Friday morning to read, to go after the jury to try to get them to side with Sarah Boone. The only problem is I don't think they were expecting them to put those videos in at the end of the day today. And I think that the defense kept that in their back pocket. That's just my opinion.
answer? That is not related to the incident as she reported.
Defense was wasting time.
Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
Yep. I can hear him whispering. Uh-huh.
Prepared for the trial or any.
In the advance of this evening, answer. I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the
No.
witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question to get the answer that I intended to get was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not, I'm not convinced he understands what the answer means or what it's
Totally
going to be.
needs snacks.
The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer. That I've been asked about. If I'm asked about something else, then I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality,
Boom.
you read that deposition and all the.
I specifically
Mic
asked you,
drop.
Mr. Owens, to point out for me I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me.
I will just say that prosecution, that was a mic drop. It was like, listen, if you're going to ask questions or you want them to render an opinion, you have to be very specific what opinion you want them to offer their opinion to. What portion do you want them to offer an opinion to? All he did was a bold statement. You have anything you want to change? Like what? Like what? Do you want me to tell you what my opinion is of the color of the sky, or do you want me to tell you what my opinion is of the ground? But if you're asking what my opinion is of the whole scene, I'm going to look at the whole scene and I may not see everything that you want me to offer an opinion to. Oh, this guy's an idiot. Well, it's on purpose. It's on purpose. It was intentional delay.
Me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress
I see
disorder.
force. Good to
Are
see
there
you.
any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us.
That's right.
If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
Well, the ones that I expressed,
other than what you've already identified.
the ones that I expressed,
Anything.
that just the understanding
anything?
that we had, that she, in the pages that I have talked about previously here today, the pages that I referred to about our agreement, that she
Do
was going to
nothing.
let me know if there were any
This is a nothing
opinions
burger.
that she had, in addition to the opinions that she gave in the transcript.
All right, thank you. All right. Any other argument, Mr. J?
Nothing.
Okay, thank you very much. All right, the court has had the opportunity to
That's what
listen
she's
to
saying.
the proffer as
Answer
read back
anything you
by
wanna know.
Madam Court
Just tell
Reporter.
me what you want to
Read
know.
the read back of the opinion that was previously offered. The portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is
Mel.
not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this
Nice.
trial court in Young v. State, 369 Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing.
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay.
No, she didn't.
All right. The court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Warner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided,
That's why you come here.
as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
Do you want it struck? Yes, to think about it.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the.
So all of this bullshit that he just went through was for naught, for nothing, for absolutely zero zilch, but waste time. That's all it was for. Why are they hiding financial things from the state and courts? I don't know. Sad the judge finally had to ask him. Yeah.
Deposition about what she said, and it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
She's just like,
and are you on board
yeah,
with the
it
strategy
didn't matter.
not to seek to strike that opinion?
It was all about wasting
Thank you.
time. This is part of the strategy.
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes.
Right now.
With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
He was not expecting that. He was not expecting that at all. So the scope of what the questions are that he can ask her are limited to a very minute section. Oh, he was not wanting this.
Dr. Warner.
Yes, sir.
Good morning.
Mark.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussion since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the
Should be back
the
probably
incident to me.
Was that your opinion back when I took your deposition?
Yes,
When
Yes.
did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Yeah.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
You didn't ask.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir. I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was the central issue in the case.
Ambushed. You can't ask questions in broad strokes hoping that they answer the questions that you want them to answer. They cannot make the case for you. They cannot offer you your defense. She can only give her opinion. You have to ask the right questions. If you ask the right questions, she would give you an opinion on that, but you never asked. That is on you, bro. If someone brings their car into me, whenever I was a mechanic, if somebody brings their car into me and says, I have a rattle, I will diagnose the rattle. If I hear something else, because I'm this kind of person, I would say, I also noticed that your belts were old and you needed a radiator flush or needed new brakes. A lot of times they're like, I didn't ask your opinion on that. I wanted to know what the rattle was, and that's it. So they can kiss my ass. I got to the point where I would just fix their problem, move on. That's it. God damn, can't type today. And he knows that. Only answer questions that were asked. She's not there to read his mind or offer her opinion for him. Yeah, that's fine. I understand.
Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware
Question
Sarah
was
Boone's on
related to
trial
a
for murder.
central issue.
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
I have a number of opinions.
Mr. Jay, anything else?
I'm just making sure you want to inquire.
This is your opportunity, Mr. Owens.
That was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions.
Damn.
As it relates to
Judge
the relationship of
is
battered
pissed.
spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts.
That's on you. That's your own fault. You have to ask specific questions. Ask specific questions, you'll get specific answers. God, has he never done a deposition before?
Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly. And then
It's your own fault.
I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation. But
well, you should have done a better job at being.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom.
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yeah, it's your
Are
fault.
there
that
any
we're
other
waiting.
opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I don't know. Ask what my opinion is on something. I can disclose that. I don't know until you ask me the goddamn question. You fucking moron. This is why you lost in the goddamn deposition in the first place. This is why you sucked at it, because you could have deposed her properly, asked her very specific questions about what she thought, about very specific issues. She would have answered those for you, but you never asked the question. And he's doing it again. We're going back in circles here, dude. Yes. No, she doesn't hate him now. She's shaking her head like this is the most asinine line of questioning, because he's asking the same fucking question he asked her. Listen to what he's asking. We're waiting on the jury trial of Sarah. And what he's going to say is, do you have any other opinions that you may offer later on? Her answer should be, I don't know. I won't know until you ask me the question. What is the opinion you want me to render? I might have an opinion of how hungry I am, or what time it is, or that I have to go to the bathroom. I have opinions on everything. God, this guy is an idiot.
Yes. Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not
Yes.
disclosed here today under
Yes.
oath?
I'm happy to answer any questions that I'm asked.
Are you
She is.
refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah
I'm
Boone,
happy to
who
answer
is on
any
trial for
questions you
murder
ask.
in the second degree?
I'm going to check the catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have. 99 out of 100 attorneys will come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a
Yes.
question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to
He
ask
sucks
them to
at
tell
giving
me
a deposition.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury.
No, that's why you're here, to ask her the question. Ask her the questions. You fool. Ask the question. What question do you want to ask her? Because she will answer it for you. Jesus, this guy must have never taken a deposition before. Well, he's only had 100 court cases, so I would imagine that might be why.
Understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here in the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
He hasn't
Can I
offered
continue
that
with my
to him.
deposition?
Yes, sir.
Oh, yeah, sure.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders in that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of
Narcissistic.
your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Different.
So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I'm leaning towards the adjustment disorder secondary to her situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
Now we're getting down to specific questions. Took you long enough. Looks like I have rabbit ears. Doesn't look like I have rabbit ears.
In your opinion, does she suffer from any form of psychosis?
No.
Yeah. No
Is
psychosis.
it your opinion that Sarah Boone suffers from acute stress disorder?
No.
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes.
Yes, I think that there is enough history to the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
Yes.
She may meet the criteria for that.
May. So it's possible? Is that your opinion?
Yes.
Definitively, you
Yes.
can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Suffered.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of
You
Sarah
can't
Boone?
do a catch-all again.
That's all the questions I have.
You can't do a catch-all question again. Doesn't work.
Any other arguments at this time?
No, Judge. she was the one I wanted.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that
It's
in court deposition. Anything
Yeah.
else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore with the related matter?
does it need to be on the record or? Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us. They've been here in court this morning.
They're still under defense subpoena.
I
We have
asked
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again. He said no.
and we're not, in our defense, our direct defense, is our possibility that based upon the information the state is going to present today, this afternoon, that we may want to seek rebuttal, and possibly through these witnesses. They're under subpoena. I'm sorry, Mr. Henderson's not here. I just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all state where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
judicial discretion as to the fairness of the proceeding that the defendant.
Oh, geez.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have given, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
Sure. This legal reason is just
Anything else,
in case.
Mr. Owens, we need to address?
Yeah.
Anything else, state?
No.
All right, let's bring back in our jury. You can continue your inquiry, sir.
And he can't even do that.
State to recognize our jury.
Yes, Your Honor.
That's to recognize our jury. I thank y'all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach. Your objections overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing when he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
And objection again.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction.
Again.
Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations amongst yourselves or anyone else with regard to that. We'll bring you back in as promptly as possible. Thank you.
Like I said, this is all a waste of time. He's wasting time because this is still early on in the day. He's had to remove him, and he is going to go ramble again. Oh yeah, this isn't the first. This isn't the second. This is the third time he's had to pull the jury out of there. And this is all before lunch.
Welcome, be seated. Thank you. Madam Court Reporter, when you're ready. Just go read it from the question, answer, question, objection. Let's just have we can buttress it.
Question, answer, question, objection.
Go ahead.
By Mr. J, question. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part when she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling that she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
There it is.
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat. Is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify. That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not out there saying Ms. Boone was unjustified in doing what she did. She's not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally.
And he's right. It is permissible arguments. Does he think by wasting time he's earning points with the jury? He's not worried about earning points with the jury. What he's doing is he's wasting time because he knows that he's lost the case. He knows that it's an unwinnable case, and he might get a little bit of headway in there if he finagles his words properly. He's got nothing to lose by doing it because he's already lost the case. What he's trying to do is waste time because he's hoping, which he doesn't know at this point yet, that at lunchtime he'll be done. He'll be done asking all the questions. He's looking at his watch. He's looking at his time. He's keeping very close track of how much time he's spending, how much time he's wasting. Because his hope is, if he can hold off until lunchtime, whenever the defense rests, this will be their last witness. Because they're not calling any more witnesses. They've already said this is their last witness. They already said they're going to finish up today. He's wasting time because he knows after lunch, jury comes back, they're a little fat, they're a little happy, a little tired, and the prosecution will read off their case. They will offer their closing arguments, which means that he gets Friday morning, he gets all night, prepare, get his closing statements together. Friday morning, he can just rattle those things off like they were nothing. He's fresh. The jury's fresh. They're wide awake. They're bright-eyed, bushy-tailed, ready to go, ready to be done with it, looking forward to the weekend. And he's hoping that he'll be able to finish his closing arguments with them all bright-eyed, bushy-tailed. They'll be thinking about the weekend, and then they go back and have to find a verdict. What has he got to lose? Yeah, I missed that part about Baker and Mo about that. Mo said, oh, they said that? I don't know. See, I don't listen to Mo and Baker on these things. So there you go. That's just my opinion. I could be wrong. I could be 100% wrong, which is illegal because Portia should go to her children and George's family in the state. I don't know what that's about, but yes, probably. Nanny Goat was just known overnight emotion was heard before they got started this morning. Just overnight emotion was heard before they got started this morning. Yeah, absolutely. That's right. Time is money. Yeah. You think it was going to be in the chat for a while, but changed your mind. Yeah, I missed that part with Baker. Why did you go? Oh, don't know.
He claims, the prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, Bader-Strauss syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury,
That's
about
not what
matters
she
outside.
said.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It's the ultimate issue of fact in this case, because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable
Good,
use of
Debbie
deadly
Webb. How you
force,
doing?
whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, the psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion. See section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer, and then I have no further questions. Please.
Okay, thank you.
I'm sorry.
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allowed the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour.
We're going to begin your cross-examination when, after
time.
we're done with the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
And that spot right there is whenever I realized ultimately he was wasting time. He was like, but it's 11:30. I won't have time for a cross-examination. And what does he do? He gets to a certain point and wastes more time. So that way it gets carried over. What am I chewing on? Gummies? Some gummy bears? Good stuff. Good stuff.
State to recognize our jury. Defense to recognize our jury. You may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right. He gets it. All right. Thank you all very much. Record reflect all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or PSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and PSS have any relation? Mr. Owens, objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek. They were having a good time. They were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Dr. Warner, good morning.
And you'll flip pages forever throughout this.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
it was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them. Correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection.
Yes.
Regarding these text messages that you provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed
Take
Sarah
care,
Boone for
Celeste.
2.5 hours
You'll see
on
soon.
October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes. Objections overruled. You may proceed.
Thank you, Judge. Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Objection, counsel.
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition. You
The deposition.
by Zoom. Yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we
Go
discussed
searching for
that these
phone
were the
time.
phone records from Sarah Boone's phone.
Yes.
Okay.
Go
And
sneak
at
it
that
up on
time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
I have it. If you just refer me to the page.
Just a moment.
You got
I do.
page 14? My question is at line 3. Your answer begins at line 5.
Oh boy. This isn't going to go well for him. I saw this part. It's not going to go well for him.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily
I would be.
overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Things head on.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no.
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
It
talk.
made my
First, you
That's
said
not my
no.
complete answer.
As I said, it made me aware that they had a
Ma'am,
volatile.
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that.
It's not my
But
complete
when I asked
answer.
you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my.
I understand, but
That's
was
my
your
complete
answer not to me? No.
Yes, but that is not.
Right. Now, at the same time,
Yeah,
Dr.
she's
Warner?
just like,
Dr. Warner,
you're an-
at the
you're a
same time, you
dumbass.
expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct?
And that demonstrated to you that they had a violent relationship.
Correct?
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, immediate objection, immediate approach.
All right, members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm
Like I said, push.
going to give you
past
similar
the lunch
instruction that
break.
I've given you throughout the last couple of days. Just give me a moment to pull it
Not
back up.
Owens owned. Yep. Ooh.
Jurors, you must not conduct any investigation on your own. This does not discuss this case or ask for advice by any means at all,
All right.
including posting information on an internet website, chat room, or blog. With that, members of the jury,
Oh,
we're going to be in recess till
come
1:30,
on.
and we'll pick up at that point in time. Thank you. State, anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much.
All right. All right. So I did catch that very last part right before lunch. I was like, yeah, I think my suspicions were correct on this. So in doing that, then I've got part 2 to this, which is going to be the fun part. Damn, we're doing good on time. I love it. Love it. Moving along really damn smooth. Let me go in here. Hold on. Nice sneeze. Ooh, that about blew my eyes out of my head. All right. Oof. Let me see if I can pull up this part 2 here that I've got. Set it off to the side. Right here. Part 2. Now, it may not be perfect. I still had more editing to do whenever I brought this thing up. So give me just a second. And let me get this thing up here. Yeah, there we go. Oh yeah, bless you. Well, thank you. I appreciate it. It was I got a lot of dust in my nose. Not that kind of dust, like dirty dust. Well, I guess that could be dirty too. Well,
Back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Steve Ketchler on behalf of the state.
William J. for the state.
Defense.
James Owens for this Boone.
Tony Henderson for Sarah Boone.
Kevin back on behalf of this bill.
Miss Boone is seated at counsel's table wearing the same clothing from this morning. Are we prepared to bring back in our jury at this time, state?
Yes, Your Honor.
Defense.
No, sir.
Yes, sir.
I'll make another motion. Judge, I had a chance to read this transcript, and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October.
here he goes. So I did catch this part of it. I haven't seen all of the videos at the end of it, but allergies is a hell of a drug. Yeah. Here's the thing. He realizes that after the last break is where he wants this to end, where he wants all the questions to end. He's hoping that they make those closing arguments, but he's going to get more than he expected. And he can't say anything about it because it makes him look like he was intentionally drawing this out.
October 4th, 2024 deposition of Dr. Tanya Warner.
Okay.
Just drawing out time.
Yes, sir. I have it in front of me.
May I sit?
Yes, sir.
I'm referring to
Sit
page
your happy ass
38
down.
at the very bottom, line 21.
Irrelevant.
Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you're all aware, yesterday, so I had to prepare for those and go through that.
Mm-hmm.
So I had not had time to process through all of my notes prior to this deposition today. Page 39. Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge set for October 7th for jury selection. Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know. Maybe we could discontinue your deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and then you have other opinions that are not going to be covered.
Oh boy, he wants to wear on this thing forever. All right, what I'm going to do is I'm going to set everybody loose for just a minute. Everybody go and take yourself a nice little bit of a break. Go grab some water, go grab some coffee, go grab some tea, grab something, grab your wife, whatever it is you need to grab a hold of something, grab it hard. We'll be right back. We're just going to do a short break here. And I'll be right back in just a little bit. I'm going to go grab another beverage. Hooray.
Sandy shores, get a tan, Rambo the orangutan. Driving a golf cart, oh man, Rambo is half crazy, yes he can. Well, that SOB's a sight to F and see. Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Whoa, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Shizzy on the dunes, coffee in hand, Rambo is a loon, and Shizzy is, well, that is too dirty to say here. Shizzy on the dunes, coffee in hand, Rambo is a loon, and Shizzy is a, that is too dirty to say here, Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Otters in the surf, hummingbirds in the sky. Rambo honks the horn and spits in Shizzy's eye. Oh my! Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having an effing blast. Oh, Rambo's rolling. Rambo takes a turn, driving to the wave. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Oh, Rambo's rolling, as the sun he's free at last. While Shizzy has his coffee, these two are having a effing blast. So here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too. Well, here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too.
right, and we are back. Woo! Glad you guys got a little bit of water break, a little bit of coffee, a little bit of whatever it might be that makes you go good. Me, I decided to grab just a nice glass of Topo Chico. See? Drinking water tonight. So you guys lay off. I would probably be drinking alcohol, but I'm not. I'm drinking a little water. I think that's what he said. Love some pizza. There you go. Let's get on with this.
And at 13, Mr. J says, what is your position? And at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental report, or if there becomes a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once the jury is sworn in jeopardy attaches. Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, and obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward, and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J? Line 9, Mr. J, I think you need to plow ahead. This is our time where the court reporter is prepared to give us a transcript by the end of the weekend. And if something needs to be amended, then she can A, issue a report, and then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion.
What's his point?
That I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard of the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for a total dismissal for prosecutorial misconduct.
Denied.
Oh.
And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21.
Oh.
The question preceding that is important. Question 14. So from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues, anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see what she's doing, that she's saying, hey, I got jammed up. I had a deposition yesterday. I didn't really have time between the evaluation and the deposition 2 days later. So you had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So
Because he knows
yes,
what
that
the
was initially
attorney's
what she
doing.
was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So I expressed.
That's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment. On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked.
Uh-huh.
Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question, well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things we mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder.
Mm-hmm.
Pages 58 to 59.
Yeah, and you
The
got to ask
overall
those
thrust of
questions.
that was any other opinions that were expressed. That was in good faith. What
There's no good faith on this.
we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my
Yeah, you would
analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about Jorge Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished?
Because the court ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should let me know if he was going to ambush me at trial. I should have known beforehand about a new opinion that Dr. Warner was going to express.
You weren't
especially
ambushed.
related to
You're
battered
just
spouse,
incompetent.
post-traumatic stress, and whether or not it was an imminent threat at the time of this event.
And the courts addressed that. Court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing, analyzed the 3 factors as required by Florida law with regard to those, and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request in inquiry of whether or not you wanted that struck and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she, based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Please do.
Judge, this deposition did not end on page 40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was was that starting at line 13. And she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. It was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe. And I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of, please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur.
Self-reflective.
So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42, where it's acting like it's concluding and is there anything else?
Prosecution.
The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his two fingers out and I hit them with a bat. So there was rule of completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd 10055, located at pinpoint 1057 Florida 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay.
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1, Charles W. Earhart.
Let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that in redirect. Is that clear?
Clear to state.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements. And you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed. I'm going to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress was.
I'm taking care of it, Counselor. Give me a moment.
How sweet it is.
Yes, sir.
Judge, I'm referring to Earhart's treatise, section 9.73, opinion on the ultimate issue. I'm on page 933.
He just got smacked down 9 ways.
This was not objectable because it includes an ultimate issue to be decided by the prior fact. And in that section 7.3.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the prior fact. The provision is equally applicable to expert and lay witnesses. The jury.
Well, you have to understand why the prosecution didn't shut up about that. Although he won, there's a reason why he wanted to get that supplemental in there. And the reason he wanted to get that supplemental in there is what he accused the prosecution of was prosecutorial misconduct. He wanted to make it very clear that there was no misconduct done on his part whatsoever. He's making sure that that's on the record. And that was the time to do it. So yeah, it wasn't about not shutting up. He knew he already won, but he was like, I want to put a supplemental in there because I don't need this coming back and blowing back and saying that it was never discussed why this decision was made. He wanted to make the record very clear, very, very clear that there was no misconduct from the prosecution. That's why he did it. Judicial. No, he said prosecutorial misconduct is what he said. I seen that hoe. They weren't pimp slap that head hard. Oh yeah.
Has the power to accept or reject the testimony of expert or lay witness.
Warmed with a little butter
that is
on
not
it.
bound by their conclusions. Merely because the witness expresses an opinion to an ultimate issue does not compel the jury to find that the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant.
My wife made banana bread. It's good banana bread.
703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at counsel's table.
I know, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment.
We've already gone over this.
Or the legal obligations of the parties to a contract. Whether the testimony of the expert is a permissible factual conclusion or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with a trial judge. For example, the admission of expert testimony that certain investments, it goes on.
I love banana breast too. Yeah, banana bread's awesome.
However, the witness expresses an opinion about the intent of the accused. The opinion, this is one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor.
If I could finish.
Respectfully, Counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble, officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 64472nd 1376 for Gamble and Fluellen 70372nd 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Can I read a little bit more? It
If you're just going to be reading from the treatise, I've already read it.
Okay, well, I just want
Yeah,
to
don't
make
read-
mention, this
don't
talking
read it
about
from
does
me
not prevent
to
a
me.
witness to testify
I've got it
about legal
covered.
conclusions or express opinions on questions of substantive law. And I was about
And he's just going to continue fucking reading. Like I said, he's wasting time right now. He's wanting to get down to that last little bit after he finishes. He is not expecting that the defense table is sitting there with these videos. He is not expecting it whatsoever, because he's thinking, oh, he's only going to have like that little portion at the end of the day. The judge doesn't want to shut it down. I can give they'll give their little spiel, and then I'll get up there and I'll make my little spiel and I'll knock them out in the morning. They'll find for me.
to finish this section. When the testimony, I'm on page 947. This testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Werner, and I wrote it down. She said, based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record. The court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains. Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No.
State?
Nothing. Thank you, Judge.
Okay, let's bring back in our panel.
How much you want to bet? How much you want to bet that they don't finish up on Friday? I just thought about something that attorney said that I didn't catch before. He said, we're going to argue about the jury instructions. I would bet that the judge already has the jury instructions already written out with all the applicable code. He probably had those students that are sitting back behind him to his left and his right. He probably said, I want you to write me a set of jury instructions. And they're going to pretty much be in line with everything that they're wanting to do. And he's going to ixnay almost all theirs. That pole smoker's going to waste as much time as he can. Oh, yeah, he is. He gets paid by the hour. He gets paid by being there in court. He wants to drag that shit out as long as possible. How sweet. Making those sweet, sweet bucks. Oh, yes, tomorrow night. That's right. F&L is tomorrow night. Make sure you go check that out. Oh, yeah.
You just stay where you are, counsel. Let's wait for them to come in.
That's going to be good. Oh, it's going to be just rock and roll. I've got to go pick up some steel tomorrow. Yeah. Mr. Owens' assimilation is inevitable per the board. There you go. Happy birthday, Tammy. That's awesome. Happy 30th birthday.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. Thank you. All can be seated. Members of the jury, welcome back. Juror number 2, back row. He's already ready. I see those hands are raised. You know what's coming. Y'all comply with the court's instructions, right?
Do you know whenever the jury is sitting back there with their hand raised, they are ready to go. They are sick of these shenanigans and they are just ready to be gone.
Thank you. Record reflect all hands have been raised. Mr. Owens, you may continue your cross-examination, sir.
If you can.
Dr. Warner, I don't want to rehash it, but just for the jury's sake, it would be fair to say that the text messages that you were forwarded by the state attorney for you to review you did not deem to be relevant to your evaluation.
Right. They demonstrate.
Ma'am, it's a yes or no question. Now, from what I understand, when the state attorney sent you the information, they did not send you any videotapes.
Correct.
So you have not reviewed any videotapes in this matter.
Correct.
The suitcase videotapes, either one of those you have not reviewed,
I have not seen them.
or any body cam videotapes you have not reviewed.
They're described in the police report.
My question is, have you?
He is going to go down through every single thing and waste time. And you have to understand that he's taking his time. He's taking big breaths, big pauses. And she's yes, no, yes, no.
You viewed any of the body cam videotapes relating to this incident?
I have not seen them. Correct.
Prior incidences between the two of them, have you reviewed any videotapes, body cam videotapes of any prior incident?
I have not.
Have you reviewed the audio tapes related to some of the questioning of Sarah Boone?
I have not.
Have you reviewed the autopsy report?
It's described in the incident report, but I did not see the actual autopsy.
Now, you're aware that we have called two experts, Dr. Michael Brannon and Dr. Julie Harper. Is that correct?
Yes.
And you're aware
And they agreed with her.
that they are forensic psychologists,
That's correct.
and you are a forensic psychiatrist.
That's correct.
So they didn't go to medical school
Yeah.
and you did,
That's correct.
Yep.
and they don't understand medical issues, so to speak.
I don't have.
I don't know.
What they understand. Medical.
I have
Do you
no idea
recall
what their
telling me
understanding is.
that they don't understand medical issues, so to speak?
They haven't been to medical school, but I wouldn't understand their medical knowledge.
If you would look on page 22 of your deposition.
Objection collateral.
That's going to work out well
Approach.
for him.
Objection's overruled.
Dr. Warner, have you had a chance to review your deposition on page 22, starting at line 7?
Yes.
Could you read down through line 11, your answer?
Yes, I'm talking about psychologists in general, not with regard specifically to your experts, which is what you were just asking me about.
Okay, but you would agree, your opinion is psychologists typically do therapy, but they don't prescribe medication or understand medical issues, so to speak.
Correct.
Overruled.
Correct. But I wasn't specifically talking about your experts, which you were just asking me about your experts specifically. And I said I didn't understand. I didn't know what their specific medical.
All right, that's what you said under oath, October 4th of this year.
Argument is sustained.
Yeah. Like, stop harping on this.
Now, is it fair to say that the majority of your work is in the field of competency to proceed and guardianship evaluations?
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week.
Yes, sir.
So as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the field of competency to proceed and guardianship evaluations.
As a forensic
That's what she said.
as a
Don't wear it
psychiatrist, I
out.
work 7 days a week.
Why
on
would
the
you want a
crisis
psychiatrist to
stabilization.
watch those? Because they're sick.
And where is that unit?
It's in located in Lake City, Florida.
So you work there 7 days a week.
Yes, sir.
And then you also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluation.
That's part of the what comes under the umbrella of my forensic work. Yes.
That's the majority of your forensic work.
Yes, that's the majority. That's the most common cases that we're asked to.
And then next in line would be sanity at the time of the crime.
Yes.
So you would make a determination and submit a report to the court as to whether or not a defendant, an accused, is legally sane or not at the time of the
Yes.
offense.
Yes, that's correct.
Is it fair to say that you also testify weekly as a treating physician through Baker Act Court?
Yes, that's correct. Every Thursday, we have Baker Act hearings with regards to our individuals who are being held in our crisis stabilization unit.
Is that in Gainesville or Lake City?
No, sir, that's in Lake City.
Now, Lake City from here is north of Gainesville.
Yes, sir. It's approximately 40 minutes north of Gainesville.
That's right, Stacy. Just lay back. Listen to the dulcet tones.
Now, I believe you said you've testified in battering spouse situations in court approximately 5 to 10 times?
Yes.
Is that correct?
Yes.
And you often refer to that as intimate violence cases?
Yes.
Reach down in between your legs and don't spill that Coke.
Now, my understanding that after you had a chance to evaluate my client, Sarah Boone, and I believe you evaluated her 2 days before the deposition, so it would have been October the 2nd of 2024. As to your diagnosis as it relates to her, do you believe that she suffers from a generalized anxiety disorder?
Not Sunday.
Now, you're aware that she was previously diagnosed prior to you evaluating her, she was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed with that.
Did you attempt to secure any other records to us?
Maybe to break will ease the seat back and unbuckle.
Did you diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or physicians come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the symptoms.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or an adjustment disorder?
I had not made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder?
It was probably within the next week when I was reviewing all of going through all of the documents in her interview more thoroughly.
Dr. Warner, did you agree you did not notify me?
Yes.
The waste of time.
You agree that when I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder.
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here.
Sustained.
Is this the first time you've let the parties know that this is your opinion?
That I believe that she has generalized anxiety disorder?
No.
That I believe that she has
Adjustment
disorder, yes.
Now, from your evaluation, you determined that she had a personality trait.
That's correct.
And you felt like that she had a grandiosity issue?
Yes, she has a narcissistic personality disorder trait.
A trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes.
Okay. A lot of people have a grandiosity trait
That's correct.
that are not narcissists.
But I never said that she's a narcissist.
Said she has a narcissist trait. More. See if someone's around the courtroom some more. Yeah. Give them love. This is so special. He will get that whenever he feels it.
Is it your opinion that Sarah Boone has alcohol use disorder?
Yes, that's correct.
And are you forming that opinion based on Sarah Boone's admission to you that she was an alcoholic?
Well, she is.
She has a history of being diagnosed with that.
Yes. It wasn't just this one thing. That was in part of her her stuff, her medical records.
She also acknowledged to me that her use had been problematic.
So you formed the opinion that she suffered from alcohol use disorder based on the history that she presented to you at this evaluation?
It was based on the totality of the information that I was provided. So medical records demonstrating that she had been diagnosed with it in the past, her ex-husband in his interview in the police report.
That's
described her
right.
as an
Omaha's
alcoholic,
smart.
in her
SMRT.
description of herself having a problem with alcohol.
Do you acquire a tolerance over time if you drink on the regular?
That's one.
Hey, Lulu, good to see
Do
you.
people also have a genetic tolerance for alcohol?
Yep. Like the Irish or the Indians, high tolerance for alcohol.
You know, as it relates to battered spouse syndrome, would you agree that that is a recognized syndrome in the psychiatric community?
Yes.
And you have heard no criticisms of that syndrome?
Thanks. Awesome.
And you would agree that's a subset of post-traumatic stress disorder?
Yes.
And you would agree that Lenore Walker first developed the theory of post-traumatic stress syndrome?
Yes.
I think at the time of this deposition, you were not sure you knew Lenore Walker.
I don't recall that.
All right, look at page 54.
Look at page 54. Look at it now. And one
Objection sustained.
Objection was sustained.
Dr. Warner, do you recognize Lenore E.A. Walker's book, The Battered Woman Syndrome, as an authoritative treatise on battered spouse syndrome?
I do not, because I have not read everything. I haven't read it, and so I can't say that I agree with everything in it.
Uh-huh. But if you want to read it to me, I'm glad to sit here and listen. Hey, Denise.
Is it clear to you that Sarah Boone was involved in a violent relationship with Jorge Torres?
Yes.
You agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with Jorge Torres?
It's been described.
Yes.
Would you describe it that way?
It's been described that way to me, yes.
It's been that way described to me.
Do you have an opinion?
She can't describe it because she wasn't there. She can only go off of what other people are telling her. He hasn't figured this out yet. Owens is a little slow. I don't think he is. I think he's pretty damn smart, but he's working with what he's got.
Sustained.
Do you have an opinion that that was a violent cycle between Sarah Boone and Jorge Torres?
It's been described that way, yes.
Do you agree that Jorge Torres was the abuser and Sarah Boone was the victim in that?
No.
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Not that she wanted to say that. She did not want to say that at all. She did not want to say that, but he forced it out of her. I listened to your conversation the other night with Shizzy and Volstorm. Ooh. I was talking to myself all the time. Or just to figure out how to get her Nina to the vet. She's a large mass on her chest, so got to get it checked out, and she's only 4. That's never any fun. So it's going to cost me at least $100. Ooh, no fun. No fun. She really did not want to say that, but she had to. And there it is. Now you've got it out there. You asked for it, Mr. Owens.
Okay, we're going to show you what's been identified as Defense Exhibit I. Have you ever seen this photograph?
I have not.
Do you see the injuries on Sarah Boone?
I do.
I do. Have you seen this photograph? How about
Show
this
you
one?
Defense Identification H.
So
You see
she's
this
seen all
photograph?
the photographs.
Have you
She's
ever
not
seen
seen all the
Do
photographs
you
at
realize Sarah
all.
Boone? I do. Are you aware that Jorge Torres
Sustained.
Yeah, that didn't work. All he was doing was holding up those pictures for the jury to see. That's all he was doing. Making sure that the jury could see him. That's why he stood there like this with it. God, show and tell again. No, we ain't doing that.
And I believe at the time of the deposition, you had spent I think on October the 2nd of 2024, you had spent 2.5 hours evaluating Sarah Boone, and about half of that time was giving her a test.
Yeah, my dog
General
has those
status
too.
examination takes approximately
Denise.
5 minutes.
Okay. Did you go through her entire history of abuse over the 3.5 year period within the 2 hours and 20 minutes that you had?
No.
Now, I understand that you indicated you may take a couple more hours to go through your file and your notes and to come up with your conclusions. Did you do that?
Yes.
Have you spent any more time on the case other than that 2 hours?
I re-reviewed the documents.
Have you made any other attempts to go see Sarah Boone anymore?
Sustained.
Oh, nice. See, she's unfallible. She's done over 1,000 of these things. She knows how to answer the questions, and she knows what's going to bind her up, and she knows how to.
You
make
agree
sure
that your
she
opinions
doesn't
are
step
subjective,
where she's
not based on
supposed to.
authority.
They're based on my education, training, and years of experience.
And you would agree they're your subjective opinions.
Correct.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Yep.
Would you agree that
She
battered
is.
women's experiences affect their perception of imminent danger?
They can.
Would you agree that
They
victims
can.
of repeat violence may fear death in a situation others would not?
They
We
may.
can.
Because someone suffers from battered spouse syndrome, they have a heightened sensitivity to danger.
They may.
They might. Are you going to ask me a specific question, or are you just going to keep beating around the bush? Ask the question. Ask the question.
You agree
She's not going to
that
spoon
people
feed it
suffering
to
from
you.
depression and anxiety are
See, I
predisposed
told you Puddle
to getting
Town,
into
she
a
was
relationship with a partner who may be violent?
They may. Each individual is different.
Are they more susceptible to getting in a relationship if they suffer from depression and anxiety with a violent, intimate partner?
They may be.
Do you agree that the DSM, I think you have it there with you,
Nice.
Yes.
directs that the clinician should consider post-traumatic stress disorder if there was exposure to extreme stress? Do you agree with that?
Yeah.
Did you do any testing to measure whether or not Sarah Boone had post-traumatic stress disorder?
No.
Is it your opinion?
Jesus. Thank you. You're praying it's only fat. She's between 60 and 20 pounds. Why would she have a Maine Coon in her? Well, if she does, you can have that removed, or just let her poop it out. It'll be fine. So let's have at least one narcissistic trait. Scary. If you have more than, what is it, 4?
Opinion that
Like
Sarah Boone suffers from post-traumatic stress disorder?
Again, she did not give me enough information to formulate an opinion with regards to that.
See? Like there's certain standards she has to go by, and she hasn't met those standards for her suffering from PTSD. Let's shuffle some papers around. I haven't really changed what I'm looking at. I'm just making it look like I'm doing something.
You agree that an intimate partner who commits acts of violence, physical violence against the victim,
Yes.
that could cause extreme stress in that individual?
To me,
Yes, it could.
You agree if that is the cause, the violence is the cause of extreme stress, that a diagnosis of post-traumatic stress disorder should be considered?
if they meet the criteria,
It might
have to meet
be.
the diagnostic criteria.
Have to diagnose it
You agree
first.
that there is a sense of learned helplessness when someone suffers from battered spouse syndrome?
Yes, that's part of this.
That's part of the
Do you
symptom.
agree that these women, these battered women, have learned the probability of receiving a beating, and they recognize specific predictive cues emitting from the batterers?
Yeah,
She
it's
wants
not-
them.
I understand, but
I mean,
you would agree
maybe.
the vast majority of intimate partner violence, battered spouse syndrome victims are women.
Intimate partner violence, yeah.
Excuse me?
Intimate partner violence, yeah.
The vast majority.
She should say yes, especially gay women. That's where most of the interpartner violence comes from, is from lesbian women. No biggie, but that's how it is.
The lion's
That's
share.
statistic,
are women.
not mine.
And these battered women have learned the probability of receiving a beating by recognizing specific predictive cues emitted by the batterers.
Correct.
And many times these predictive cues result in a high level of anxiety.
Yeah.
And in that situation, the battered women may attempt to reduce through several different means, one of which is to avoid delaying the beating.
Oh God, spit it out, Dorcas.
Talk about that for a cycle.
What is a basal instinct?
A Basel instinct? I have no idea.
Primal,
no idea.
primal fear.
Primal fear is just being afraid.
Is that a natural instinct that animals have?
Yes.
Fight or flight instinct?
Yes.
You don't even think about it.
Correct.
Man, what's your point there? Come on, Buck Owens. What's your
Do you agree
point?
that victims of battered spouse or battered woman syndrome suffer from self-isolation, suicidal thoughts, and oftentimes substance abuse?
They may. Each individual is different. So they may.
And they may show
Yes,
signs
it
of
is.
physical injury and illness such as bruising and chronic fatigue.
Yes. That's signs.
Uh-huh.
The syndrome, battered woman syndrome, is the psychological
Spot's
effects of
giving
living with an
One of the
intimate partner
nastiest
violence.
smiles.
They may have intrusive memories, or they re-experience past traumatic
Like
events
you're
in their
wasting
mind.
my time with this shit.
They have high levels of anxiety, hypervigilant when something doesn't seem right.
They may.
It leads to this fight or flight response that we spoke about. They have problems with sleep.
They may.
They often go into denial,
They may.
minimizing what is happening to them,
They may.
numbing their emotions.
Some of them.
Disassociation. A battered woman may often develop a defense mechanism of being able to psychologically detach from their body during the traumatic experience.
Sustained.
Like, get on with it, buddy.
Panic attacks, severe depression, very low self-esteem,
Yeah,
poor
that's all
body
he's
image,
doing.
disassociation, learned helplessness. All these are symptoms of a battered woman syndrome.
Sarah can't handle the truth.
Sustained.
You agree panic attacks is one of the symptoms of battered woman syndrome.
Sustained.
What are the symptoms of a battered spouse syndrome?
They can be numerous symptoms, from anxiety symptoms, mood symptoms. They can have psychotic symptoms. It can be any vast majority of symptoms, substance abuse symptoms, any vast majority.
Do you agree fear is a symptom? Somebody in a
Yes.
constant state of fear.
Maybe, yes.
In terms of the abusive partner, do you agree that they would hit the victim,
Some of them, yes.
kick the victim,
They may,
punch the kick the victim,
they may,
choke,
Punch to kick the victim, slap him
Choke.
around,
they may,
burn,
fart on him.
destroy their belongings,
they may,
use weapons to hurt them,
they may,
threaten to hurt them, their children, or their pets,
they may,
take their car keys,
they may,
take their
They may.
debit card,
They may.
take their vehicle,
They may.
control where they go and who they see,
They
force them to
may.
have sex when they don't want to.
yes, they may.
Doesn't mean that all of them exhibit every single one of these symptoms. But Jesus, dude, you're gonna read her the whole book. Like I said, he's wasting time. Let's go to this page. Come on, man. Put a tab in it. Really? You're just gonna sit there and flip those pages. What a
Dr. Warner.
loser.
I know you spent a short amount of time with her and you're saying you didn't get some of the answers. So whether or not,
Yeah.
Stating facts.
Objection sustained.
Yep.
if you'd have spent more time with Sarah Boone, could you have uncovered as to whether or not she suffered from battered spouse syndrome?
I agree that she met the criteria, or that she had battered spouse.
How about post-traumatic stress disorder?
It's possible.
Thank you.
Any redirect examination?
Yes.
You may proceed.
Well, anything's possible. He's wasting time. That's it, Lilu. That's it.
In
He's
your
just
decades
wasting
of
time.
experience, have you ever treated patients that suffer from trauma disorders?
Yes.
How frequently would you say you do that?
I
Oh,
have
yeah.
patients on my unit right now that I'm treating on a
Thank you,
regular
Tammy.
basis who have.
How about patients that meet the criteria for battered spouse syndrome? How many would you say over the course of your career?
Probably 5 to 6 a month on my inpatient unit.
And that's a lot of months.
Yeah.
How long have you been doing this?
Since 1998, when I began my career at the University of Florida on faculty.
Now, on cross-examination, you were asked about some diagnoses, correct?
Yes.
Any of these things that you talked about, narcissistic personality disorder, adjustment disorder, anxiety, battered spouse syndrome, any stress or trauma-related disorder. If the state wanted to ask you those opinions, would you have been receptive to more materials before making any opinions about those topics?
If I wanted to be.
Is it your testimony today that you don't have enough information to necessarily make a complete and proper diagnosis on any of those things since you have not been provided those materials?
Correct.
Now, you testified that she does meet the criteria for battered spouse syndrome,
Yes.
but you would be receptive to any evidence that you were provided, right?
Correct.
Yes.
Going back to what you testified to on direct when the state asked you your opinion about this case, everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No.
And why is that?
Because again, she just.
Objection, Judge.
She's just like, there. I think that the judge is going to overrule on this. He's going to say, no, go ahead, answer the question. I haven't seen it, so I don't know.
Based on your conversation with Mr. Owens, you've indicated that your opinion did not change, and now would you answer why?
Yes. So based on my interview with her, the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
And I'm showing you what has been marked for identification purposes by the defendant as I. Does this photograph inform you as to what happened?
No.
Does it
No.
inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it inform you as to who the aggressor was?
No.
Same questions for G.
H, I, J,
F.
K, L, M, N, I.
E.
No.
She did well yesterday.
D.
Today ends it for her. Yeah, that is right. Yeah, that's
If those
exactly
specifics
what
as to what happened and who was the aggressor is dependent upon the credibility of somebody, would you want to take into account all the things that can make a person credible or less than credible?
Yes, you would want to take that into account.
When you talked about alcohol use disorder, would you take that into account if somebody is under the influence of alcohol or been consuming alcohol when they relay a history as to things that happened?
It's just like, yes, because every single one of these play a part in your diagnosis.
Would you consider somebody's alcohol use and level of intoxication in evaluating the credibility of them as a historian?
Let's just say.
And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Again, that doesn't change your opinion that you gave when talking with me on direct examination.
Object. Ask and answer.
Overruled. Specifically about this question about the testing that you did not perform. Did this lack of testing have any change or effect on your opinion as to whether or not battered spouse syndrome applied to the facts of this case?
No.
Oh.
You were questioned about insanity on cross-examination. Do you recall that?
Yes.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct, that you are equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct. That's not that they would be equal.
Yeah.
So even if you do have
that's
battered
good.
spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
No other questions?
In the eyes of the law,
Statements
Other
would be
hand.
released.
Yes.
Defense.
Just so we have a phone number, we can reach out to us.
All right, ma'am, you're released, potentially subject to recall. Thank you.
oh. Look, Rudolph is in the courtroom.
State, you can call your next witness.
Judge, at this time, the state would move P for identification and evidence.
Hey, it's a videotape on the.
he's trying to explain to him, son, the bullshit you're trying to play, guess what? We're going to destroy all credibility of your client. I told you should have taken the deal. But guess what? I'm going to show this video and it's going to rip everybody's heartstrings out of their chest. And there's no way possible that she's ever going to get out of jail after this. It's going to make you feel really bad. It's going to hurt your soul. It's going to hurt everybody's soul. But I'm going to do this to you. Just so you know.
State moves P for identification and evidence.
Yes, I gave it to you. She is so stupid.
Any objection to what was pre-marked as P?
Any objection to what was marked as P? Why are you marking it with P? Don't mark it with P.
Members of the jury, it is 2:52 in the afternoon. The next part of the state's presentation are going to be some videos and other things that we read to you that may take a little bit of time based on the length of them.
2:52. See, Owens was not expecting that. Owens was expecting him, last witness, that he wasn't going to do anything. That disc is a death sentence for her case. I used to say it was a toxic relationship both ways, but now I'm under the impression it was her instigating and him blowing up in fits. Yeah, anyone smell smoke? Mr. Owens, this is where you're going to wish you took that plea deal. By the way, you're welcome. Yeah, that's exactly what he was whispering in his sweet little ear.
So we're going to go ahead and take our afternoon break at this point in time. Similar instruction I've given to you over the last couple of days. Please do not conduct any independent investigation.
Oh my, there's only one way to celebrate this kind of thing. Only one way in the world to celebrate it. And if you got to celebrate, you got to celebrate in the best possible way. You just get a...
Spit on that thing.
No, I'm just kidding. There's better ways. Don't you hate when your brother has that?
Well, what's
and you,
going on?
And you don't.
I know. God, he's such an asshole.
I know.
So annoying.
We'll put
Hi,
him in his
everybody.
place.
Tammy, Sir Frank Otter, Ballstorm.
At least it isn't this one. This one would drive me nuts.
I love you. You love me. Can I lick you where you pee? What?
Oh my God.
Yeah, that's just creepy. I'm weird. That's creepy.
that one is still fun. One of my favorites.
Yeah. Yeah, no, I caught the part that I caught was when defense was losing their shit over the cross on Dr. What's-Her-Face. Like right at, not even the beginning, like midway point, I think.
Yeah.
Yeah.
Let me see, because I had this. I still hadn't completed editing this.
Hey, Debbie.
And yeah, this is where I uploaded this without getting that perfect clip in there where I knew it was ending, because I had to do it in two separate things, because for whatever reason, while I was recording it, I hit the pause button or something. I don't know. So like it was paused and it wasn't recording. It was still playing the video, but it wasn't recording. I was like, son of a bitch. So I had to go back and figure out where it was at. It happens. Yes, she's an eat. I knew you guys would like that. All right, from what I hear, this is pretty rough. So explicit images, dirty words, and general malfeasance. Just coming at you.
Y'all make me see. Thank you. State, anything we need to talk about? Defense? All right, we'll be in recess until 5 after. Thank you.
Yeah, so they took a little break.
Yeah, and I finally got caught up on the ME testimony too. So there's one part that I'll show you that kind of struck me because I caught part of the video, some of the videos, not all of them. But when we come to it, I'll show you what I'm talking about.
Cool.
That kind of made sense to me.
Cool.
So he was here this morning, and she called us this morning, okay? He's now back. And he knows, but he can't get right now. So, no, he just want to get in. Well, you got a piece of paper real quick. You can get it for me, I'll give it to him. You really get all this money? She had. If you get it real quick, we'll give it to him. You're not getting all this money. Okay, make sure that.
Publishing from folder OCSO 19-078009. First item is a PDF of photographs.
That's her. That's him. Oh. Him. That's him with a look at his eye, right below his eye. His neck.
Yeah. See, all this, and it goes back to what we were saying before. All the pictures and everything that she's taking, whatever else she's just using it to set him up. She would go after him.
Yep.
And
second item is the single video
the
starting.
vast majority of it, I believe, is in defending himself, if there's anything.
Yeah. Oh, hey, Toy, how you doing? Good to see you, girl. Thank you for that. Loves ya.
Oh, Toy.
Oh, I have been here. Yeah, I thought you looked familiar. The last time I was here, you guys had a fight at the bar. No. Oh, he came home from the bar. Someone came home from the bar. Hey, who's that? What? What? Hey, George?
Yeah, what's up with phone line? Is she there? She's dead. Okay, can you just be drunk? No problem.
Come on, sir.
You're gonna need a call. You go upstairs.
Okay, come on, George. Okay.
What? No, they're not staying on there.
Okay. And I think this is, no.
No.
Sarah, are you serious?
Yeah, I don't want to be punched in the neck.
I'm gonna slow it down because I can't keep up with what's being said.
Told you I will not hesitate. That's okay.
Had him arrested while he was sleeping.
Oh, he's nice enough to me. I just figured your shoes from last time. Ma'am, you want to get driving for me?
Yeah, there's a pad in here.
Yeah.
Did you have a wallet you want to bring with you or a cell phone? No. All right. Sarah, are you serious? Sarah, are you serious?
I seen the negative.
Sarah, are you serious?
Are you serious?
Yeah, you can. I'll be right back with you.
Oh, we're gonna go pop down here.
I wish I had the regular footage of this and not just the stuff that's on the screen, because it's so dark you can't see half of what's going on, and the audio sucks.
Yeah.
I might skip forward a little bit here.
Well, there are some important things that are said too that you can pick up on.
Bastards. I knew that was going to happen. Let's do it again. Here we go. See if I got closed captioning yet. Damn it.
Well, let me just
Still
get
not
down to the
closed
bottom of it, okay?
George, I want to talk to you. I want to ask some questions. I have you in handcuffs, so I've got to read you something real quick, okay? Do you understand? Yes. All right. You have the right to remain silent. Anything you say will be used in a court as evidence against you. You are entitled to talk to an attorney now, have them present now, or at any time during questioning. If you cannot afford an attorney, will be appointed for you without cost. Do you understand these rights as I've read them to you? Okay. At any point hereafter you wish to remain silent and have an attorney present, all questioning will stop. Do you understand that? So even if you want to talk to me at first and you change your mind, just let me know. Okay? All right. Has anyone at any time threatened, coerced, or promised you anything in order to induce you to make a statement? Have I promised you anything? Have I bribed you? Have I said, hey, if you tell me, give me a statement? Has any of that happened? No. Okay. You understand these rights as I've read them to you? All right. So, what were you two fighting about tonight?
We weren't fighting at all.
Okay. What are you fighting? I'm going to take that in there for that. Huh? Okay. I'll take the statement and get the statement done.
Oh, with him?
Huh?
For him?
No, for her. That way you can fill this out while you're 10-12 with him.
Sarah.
I'll get her information from her.
Yeah.
Okay, listen. Why did you throw it in? What up? Okay, can you explain the bruises she had? Let's look off the nose.
She's a drunk. She falls down all the time. Oh, good God.
one your version of what happened.
This is my number. Call me 1-800.
Yeah.
Welcome to the Nut House. Rapper, good to see you. She's filling out her driver's license information. I don't think I need all that. This is not giving me anything. Okay.
59.
That was nothing.
Yeah.
First file is a PDF starting 48-2019.
Did he say a PDF file?
Right. I kept hearing that. and I was like, why the hell? Oh, wait a minute. Oh, no. Okay.
Oh, there's the picture of her ear.
Right.
There's a picture of her face.
Second file is an audio file, 911 call, publishing.
It's not technically an emergency, just you've been there so many times before. I'm not there, but I'm just trying to go home.
What is the address?
4748 Brant Court.
What was the street name? Brant Court?
Brant. F as in Frank, R-A-N-T-Z as in zebra.
Oh, is it France?
I don't know if it's there or not. I'm sorry?
Ma'am, is it France Lane?
I'm guessing so. It's Frank's Court, right? It always comes under France Lane.
Okay, what exactly is going on?
I would like to go home, but I can't go home because he's there.
Okay, do you have some sort of restraining order against him, or?
He has a no contact.
Is there an apartment number?
3.
1 second.
See, that's part of the problem. She calls so often about
I can
bullshit
go home.
that the way she starts that conversation out, she automatically assumes that they know who she is and what she's talking about.
Exactly.
And who George is.
Yeah.
Because she calls so often.
Yes. A lot like a certain turtle purgatory.
Which just freaking irritates me because they're tying up 911.
With the picture. My sock monkey. They like the sock monkey.
I don't even know if he's there or not. He was there earlier, but I can't go home.
Okay, so do you want us to do a standby with you?
What do you mean?
They're like, Sarah, this is
Escort
hurting
you
you.
to the residence, or
Should we
that
take that
another
plea deal now?
individual? Like,
If
No,
I
screw
could
that.
please,
I wouldn't.
can
No,
you guys
that
go
shit's
over
off the
there
table.
and
After all this,
I'm
no.
pretty sure
Yeah.
No,
and he
you're
left
going to
me
get
out
your ass
earlier,
tattooed to
so
the wall.
I think he's probably there still. I'm
Yeah.
not going over there with him then. I'm not.
okay, does he live there?
No.
Okay, so how is he inside the residence then?
He has a key that he took.
Okay, so is he breaking into the apartment?
He's not breaking, he's already in the apartment. As far as I know, I don't know, like, if he's there or not. He knows where I hide my key.
Okay, what we can do is we can meet you a block away from the residence and go with you to the residence.
I don't know. I tried
Yeah,
calling
she's
him
full of
to
shit,
ask
too.
him
She
to
knows
leave
damn well he's
if
there.
he's not already.
Yeah.
So I have my 8-year-old that I'm trying to watch out for right now. So I'm not really sure what I'm supposed to be doing. I just want to go home.
Okay, if you want to go home and you're not sure if he's there or not, we can meet you when you're about 5 minutes to a block away and go with you to make sure he's not there.
Okay, well.
Uh-huh.
Okay.
Yeah, the lie isn't working. She
I'm
didn't want to
about
walk
to
the
get,
block.
to be honest with you, kicked out of my apartment because you guys get calls so often, and my
Oh, the story changed.
Based on everything, and the neighbors complaining about everything. I'm trying to avoid that. I just want to go home.
Okay, regardless, the deputies are going to go to the apartment, whether it's with you, what I'm suggesting you do, or it's what you want to do. Just have them go to the apartment. So regardless, people are going to see that there's deputies going to that address.
Okay, so when I called you guys like a couple of
Yesterday,
days
I was so
ago,
much like
and they just
Amber
made
Heard.
like not a ruckus, but like they made it like incognito, which is what I need because I'm going to get kicked out of my place.
Okay, when we do a standby, ma'am, all we're going to do is accompany you to the address and the deputy to make sure that he is not there, and then they will leave. If that's all that's going on in this situation right now that you're calling for, it's not going to be like a big deal.
And what happens when he is there?
If he is there and you don't want him there, you can have him trespass. They're going to make sure he can leave. I mean, if he does not live there, like you're saying, if he should not be in there, you can trespass him. You already have a no contact order with him. They will remove him.
Okay, well, there was an altercation earlier, and I'll be honest with you. There was an altercation earlier. So that's when he came in, the altercation happened. So that's when I left. I fled.
That's right, KPM.
You fled.
Now I'm at my former husband's house.
Okay, would you like the officers to meet you where you're at right now?
Just
I don't
her
want to get
response,
arrested.
that isn't going to work.
I don't, because I fought for myself, and I have my 8-year-old, and I just want to go home and sleep in my own bed right now. But I did fight back. I'm not going to lie. So.
Okay, well, I mean, if you're wanting us to meet
That's
with
all
you
you
or
do
go
is
to
lie.
your house, I mean, I don't know what
that is
they're going to do.
absolutely
They're
right.
either going to arrest anyone, arrest you, arrest him. That's all up to the deputy and what he concludes from the situation that's going on.
She's bad.
So it's
Bad
right
news.
now it's just up to what you want to do right now. If you want to do a standby, we'll accompany you to the residence. I mean,
yeah.
It's really just what you want to do.
I know. I think I have to say what's going to be tomorrow. I just.
Or what I could do is I can have a deputy call you about the matter. If you want to speak to a deputy directly, and if you want to do that first before having us respond out there. Okay. What's your name?
Sarah.
Hold on a second, Sarah.
Thank you for your help. Actually, more ways than one.
And is a good phone number for you 407-716-8684?
Yes, ma'am.
Okay. I'm going to set up a call for a deputy to call you over the phone. So you can talk to them directly and see what they say about the situation. And when they call you, it'll be from a blocked or restricted number. So if you get a call like
I want to
that,
watch my
just
son,
answer,
but
it's going to be the deputy, okay?
Yes, ma'am.
All right. If anything changes
Yeah.
or you decide you just want us to come out and give us a call back, okay?
Yes. What was your name?
My name's Rachel.
Rachel, thank you so much for your help, and I've got the phone right here on my lap.
Okay, perfect. Bye-bye.
Thank you. Bye.
Publishing the one video in the folder, starting with 1924, from 0 minutes to 20 minutes, 41:30 to the end.
torrid relationship. I'm guessing this is a deputy showing up.
Yeah.
Yeah, Pete. We have both of these. Only already. Is there a back door or a sliding door?
Yes.
No. Do you attend all this stuff now? Thought that was open for a second. Locked.
Tripped over her fence that she put back there. Oh, God.
But here's the thing. Every single time he's asleep. Every single time.
Every time he's asleep. And I mean, here's I think what really grinds my gears is if she's doing this, if she's calling the cops whenever he's asleep, it always seems to be at night after he's passed out drunk, and then all of a sudden she's calling the cops. No, that doesn't sound right. At 1 a.m. to bring her a key, which she could have just brought with her. I don't know. And every time they're having to show up for bullshit like this, they could be out doing something to protect the people.
Anyway, you want to call your ex-husband? You have a phone? There's a charger in that.
It's not in the house. It's not safe. It's not in there. Just because the doors are locked.
I don't understand. You think he's inside?
Yes.
Oh, yeah, she's the manipulator. She's the abuser. I'm not saying that he was perfect or anything. Clearly not. But anytime he did fight back, it was because she was going after him and he just pushed him over the edge. That's what I firmly believe.
That's how he got in the suitcase.
Point.
The keys in the house is not coming to the door, but you have my spare keys. I can't get in. If you could, there's no other way of getting in my house.
Wow.
Unfortunately, can you please bring me my spare keys? Yes, please.
What a bitch.
The front door and back door. I have no way of getting it.
Where's he live on then?
What's up with the light? Why does it keep blinking on and off?
Right up the street. He'll be here in like.
Perfect, thank you so much.
Must have a high sensitivity motion
This
sensor.
your, who you think is your ex-boyfriend, is that correct?
My place.
That's my place.
Your boyfriend or ex-boyfriend?
I don't know.
Somebody pretty. Okay. Does he not have any weapons?
No. No.
He was arrested last week for bad behavior.
Hey guys, I just want to take a picture right here. You can see that.
Saw he was arrested before, was that also like one? Last week.
Yeah. But
And seeing so many departments, so many policies have changed at this point, because this is 2019. So this is like right around the height or the upward spiral of believe all women, right? So anything in regards to this domestic violence or whatever, a lot of departments, unfortunately, the officers have their hands tied, so it doesn't matter. So a lot of guys have gotten fucked over because of this shit.
Yep.
This part here, so these two are right here. What kind of vehicle does he drive? See a little bit of movement on the line.
it's about my dog. She's okay. With my dog.
Oh, gotcha.
So I have a feeling it's probably tight. Just put that one.
Oh, I'm sorry to hear that, Scranton Strangler.
Does he have anywhere else to go? Or is this the only place you have?
His parents' house.
Where's that at?
You should just know 7:30 every night. If I can do it. Except tomorrow. Tomorrow's Halloween on F&L over at the Experts. Oh, yeah. That's going to be a blast.
Guys, can I say something now?
Sure.
If both doors are locked, he has to be in there.
Why is that? We can't lock it from the outside?
No,
Doesn't he have a key here for here though?
unless he took my spare key, which I'm pretty sure he probably did. He has to be in there,
Why does he have to be in there?
especially with the back door.
Is the spare key, was the spare key in the house?
I headed outside because he wants me out over there.
Yeah, it's scary that women would do that.
If those doors are locked, he has to be in there. Y'all can have to see, y'all can open the door.
Hey, you're gonna stay outside till we make sure nobody's inside.
Okay, bye. Bye-bye.
Hanging out here.
I'm not going there. There's no weapons. There's no weapons.
That's for minute. That's for minute.
That's Lucas.
I know. County 120. 124, Charlie. Thanks, sir. Can we get minimum traffic for a building search? Are you making announcements? Yep.
You guys don't have to do that.
Man, we don't have to wait to do things. Just let us do our thing, okay?
It's like you guys don't have to do that.
Sheriff's office. You guys come on out. I got a dog. George.
If he's passed out drunk, he doesn't even hear him.
Yeah. We have a ton of plants on the right side. That's when you get that stairwell, just fuck your, right up, or don't pull up, that's when you
Ton of plants on the right-hand side. dad is.
If you're up there, let us know. Because we're coming up anyway. Go ahead. Run, whenever you're comfortable.
Yeah.
Open door right there. I think that's a good bedroom. Okay. Just get that look on. Yeah. Have someone come in and bring you on that way.
Nothing like coming in and finding some guns pointed at you.
Mm-hmm.
Boy! Show your hands. Come on, hands up. George, step out with your hands up. Put your hands behind your head. Hey, turn around. Face away from me. Turn around. Walk back to me.
Like, what
Walk
the
back.
hell?
Walk back.
And look at how tiny this guy is. Just, he looks like a 12-year-old child compared to these guys.
Well, but at the same time, I mean, clearly he's not. To me, I wouldn't say that he was, but I mean, I've seen people a buck soaking wet and they're on meth or PCP or especially bath salts. Oh my God. People on bath salts, Jesus. They'll fucking tear through a tank.
Yeah.
Okay. All right.
Wow.
Let me ask you a question. Yeah. What happened today? Got a light here? Yeah. You just gotta pull the thing? Yeah. What happened? I don't even know what the heck happened. There's a reason you're hiding the bathroom, so don't act like we're not up here for no reason.
No, I know that.
Okay,
I'm hiding in the bathroom because we had a discussion and as usual, and I am in the wrong.
Oh, man.
What?
Mm-hmm.
I am with what is it called?
That is a man that's just been beat down.
Yeah. Yeah.
Like, I'm in the
and
wrong.
here's the thing. So she probably wanted to stay at partying or whatever else. This dude is working. At this point, I don't think she's working.
No.
Apparently, at one point, there was that I think she had a job or it was temporary, whatever. But he's got to get up and go to work the next morning. Yeah, he's a drunk. He's got problems.
Yeah.
But the dude's fucking working. And he's trying to keep what little of his life he has left together. And every single time he turns around, or apparently just wants to go to bed and doesn't want to go party with her or whatever the deal is, fuck it. She's fallen down. Oh, okay, I got some more bruises on me. I'll just call the cops.
Yeah. And
It's called no.
yeah, he's got a no contact on her.
When's you got released? When's your release? Because you arrested last week, right? Yeah. All right, when did you get out?
Let's say 3 days ago or something like
It was
that.
on the weekend? Yeah. Today's Wednesday, or was it Monday? Or was it this weekend or was it Monday?
The weekend.
Okay. After that, did you guys talk and come back here and this weekend? And everything is fine between you two? So tonight, what happened tonight?
I don't know what happened tonight.
George. So you cops in front of you. You're hiding in the bathroom.
Yeah, I know that.
Okay. That's not for no reason. Right?
Wifey is nuts. She always freaking starts stuff. And she,
So that's what I'm asking. I'm telling you what happened.
she puts it on me
Okay. She puts it on you.
all the time.
Well, you're not, none of that gives me any insight as to what happened tonight. You
Nothing.
both are very big. She's very big, you're very big. Any more than big,
What is she being big about?
I can't discuss what she's discussing, but you discuss to me, right?
We just want to hear your side of things, but everybody wants to hear my side.
Yeah.
What side?
Georgia General.
yeah, what's that?
Mm-hmm.
Because this isn't the first incident between the two.
Oh, I know
She's
that.
been arrested as
I
well.
don't have a side. I'm just waiting.
Yeah,
for
he's
it.
like, fuck it. Yeah, because it doesn't matter. He knows he's going to go to jail either way.
Yep. At least you can get a good night's sleep.
Y'all drinking?
Yes.
Both of you?
Yes.
I can smell alcohol on her. So I know I already knew that, obviously. But,
we've been going through a lot. Right now, I work at Ace right here across the street.
He's working. He could lose his job over
We're
this.
going through a lot, and they're about to shut down and whatnot.
that is,
Yes.
okay. Just tell her not something.
I don't think anything happened. I think they probably got an argument earlier that night, and
Well, it's like what we were looking at the other night with all those other pictures, right? And we see that one where he supposedly, according to her, stabs her with that steak knife.
Right.
And we go through, and you were talking about the walking boot. Well, when you look at her foot, that bruising on there
Give us a couple minutes.
would explain to me why she was wearing a walking boot to begin with. I think she fucked herself up. She fell down, like what you were saying. And so I don't know if she had a small fracture in there or why they had her in the why. That would be my assumption. I mean, that's kind of what the bruising pattern on her foot looks like to me.
Yeah.
But guarantee she fell down and got poked in the leg by something. But no, he stabbed her with the steak knife. He did all that. Bullshit.
And because they probably told the truth in the first place, whenever they were in the hospital, they treated her without any question. And then she's got this photographic picture of something and attributes it to him. He can't dispute it because he's deceased.
Yeah.
I don't know. She's about to get a good case of cellulitis.
Did she injure you today? Did she hurt you? Maybe emotionally or?
Oh, well, KPM, if you look at it and you look in the very center of it, it does look like some kind of a puncture. But apparently, and so if you look, sometimes you have to extend the wound out. And so the cuts on the outside were not from a steak knife or anything. Those were intentional, like surgical, if you will, type elongations.
Yeah.
So they had to extend that wound out in order to get in there and suture up. I don't know. It wasn't arterial, that's for sure.
Well, they might have had to go in to see if there was anything that was damaged.
Right, and it could have been going down, because going down through that side is where your cephalic will start coming around, and then where you could do a cut down near the medial malleolus there, right? So, and they also have to clean it out. And I don't know what she got stuck by or if there's any debris in there, but they got to do a debridement as well, and then suture it from the inside out. So a lot of times you have to extend the wound out. Yeah.
You don't tell me what happened. How can I help you?
That's my woman.
Okay.
Still listening. I have to step away for a second.
Is that as much as you want to give me?
What's she saying?
Jorge, I told you I can't say that. You're not going to tell me what's going on. I'm not going to tell you what she's going to see. You know exactly what it is. I can't feed you information. Why don't you ever call us?
Why?
Why not?
Would you call you? Would you call?
Good. I've never been in that position, so I can't say.
That is your beefcake.
Anything like that. My girlfriend's mom, she's crazy, so.
I am. What am I gonna say? I'm actually wrong right now.
You're in the wrong right now?
Yes.
No matter what way you're saying you're in the wrong, no matter what way you cut it?
No way shape or form, you know that I am.
I can respect the responsibility, because most guys won't even take responsibility.
You're gonna take me in no matter what.
Make it a little better.
Yep.
That's really true. I take girls to jail all the time.
Bingo.
That better do all the time.
No, you're gonna take me in because I did the no contact.
You know what that no contact said?
Yeah, I'm fucked.
What is it?
I am fucked.
What are you not supposed to do?
Oh man, you're the one that took me. How you?
I think it was.
And that's part of the reason why she was doing it, because she knew because of that no contact that they would take him away.
They're not. They're a little similar. Or look a little. Our hairstyles the same. Yeah. Yeah. It's not the same. I promise. No, I promise you. I will remember you. It's not me. But what did no contact order tell you? What did the judge tell you?
I heard that and I was just like, what does that mean? I'm fucked.
Right? Yeah. Yeah. And so that's why she was doing this. Oh, yeah, come on over. Oh, yeah, we'll play nice. Oh, everything will be great and wonderful, blah, blah, blah. Knowing that he still has his contact order, and he knows that. But in his mind, even though I don't know what his other family situation is with his brother or whatever, but that kind of ties into what some of the other guys in here were saying, whether or not this is premeditated. I don't think it was hyperbole. When he's on the phone with his brother and she's telling him, directing him, oh, tell him about choking, blah, 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 blah. And then apparently she goes and talks to his brother, and then somewhere in that conversation makes the statement to the effect of, oh, it'll be taken care of, or I'll take care of it, or I'll take care of him. So she already had somewhere in her mind that one way or another, she was going to end up doing this guy in. She was going to get rid of this problem because it was no longer fun or whatever for her, because he didn't want to play along anymore.
Yeah.
And so then they're fucking around that night. He gets in this suitcase, or she stuffs him, whatever it is, and she sees her opportunity. Oh, I can play this off as an accident. Or maybe she made
the opportunity.
Or she made the opportunity. Yeah.
She put it down there going, let's play hide and seek.
It's cleaner than putting a fucking copper jacketed antidepressant through his grape.
Right. Maybe the let's go play hide and seek was her idea. Yeah. We're only hearing what he did. What if it wasn't her saying, let's play hide and seek? You're it. Tag, you're it.
Yeah.
And then she goes, I'll go count to 10. I'll go upstairs and count to 10. And he sees the suitcase there. Says, oh.
Or like I said, I still can't put aside the fact that this started upstairs.
Big possibility. Maybe they were just laying in bed.
Especially with some of when I went back and actually watched the ME part and some of the bruising and so forth on his back, which sounded to me more consistent with a wider surface that he's being bounced off of, which was make more sense to me with the stairs.
The copper jacket suppressant.
What's
that?
You
like that?
Oh yeah, yeah, yeah.
Oh, jeez.
What about in relation to this plane? Are you like,
Oh yeah, no. Yeah.
Yeah, this is you just having a place to go.
You know, it's too bad he didn't have his wits about him. He could have said, well, the agreement was I stay here and she was going to stay somewhere else. So I was obeying the no contact order. I mean, that's what I would have said. Just say, you got to play this game. Be like, listen, officer.
Well, but it depends on how it reads.
Well,
but it depends on how it reads. It doesn't matter if it's just inclusive in general of the address. Whether or not she's there would be irrelevant.
Yeah, that's true. That's true. Still,
it depends on how it's written.
Shot.
Yeah,
it'd be worth a shot.
Because even some TROs, ROs, whatever, will have in there whether or not somebody can or cannot have pew-pews, for instse.
Right. It'll also give an
it just
address.
Depends on it just depends on how it's written.
Yeah. If it was commingling, they would probably give the address. You can't be within 500 feet of this address. Some shit like that.
Yeah.
No, I've got a place to go.
Your mom's place?
Yeah.
They still live there by Twisty Tree?
Yeah. I do my homework. But before you guys take me, can I get at least put your shoes on? What kind of shoes you want? You want some comfy ones, some fly ones? Like those, get no fly ones. These, I like these leather ones. Get the blue ones, please. This one right here? Yes. Which shirt you want? And that's black one, but this black shirt? Yes. You want socks? Yes, they're right there. You got a wallet? My phone's downstairs. That's it. Have a wallet. Oh, not that shirt. There's another black shirt that's comfy. It's this one. Is that the other one? They're both inside out. I don't know. The Ace? Yeah. You like the Ace one? Yes. All right, we'll do that one. Can I? Yes, sir. Please, what? What do you need? So I can put them on. Oh yeah, we'll handle that in a second. Let's get the shoes on. Okay. Where you say the socks were? Yes. Is black or white? The white ones.
Yeah, he's being respectful back to him also. You don't see him fighting. You don't see him cussing him out. Don't see him yelling at him.
3 years. 3 years, really. Does it look nice? My phone's somewhere in the house. It don't really matter. I'll answer. Okay.
Can they prove premeditated murder? No, they can't.
Just step up right here for me, please. I just gotta get him. Are you okay?
If they could have proven it, they would have pulled it up on her.
Oh, okay. Okay. Yeah, no, it's okay. Just a quick question. He's asking about his phone. Do you know where that'd be?
No, I don't know what's going
Okay. You don't have it in your vehicle or anything?
I do not.
Okay.
I happen to find myself. Wait. I need my car keys.
Okay. They're not on here. They're inside the house somewhere.
You seen them?
I haven't seen them, but.
Seen them?
They're in there
Please
somewhere.
don't drive. Please, lady, you're drunk.
They're not on here because I had to search him before he got in the vehicle.
Is it supposed to ask? They ask them where they are, please?
Okay.
I only have one, sir.
Okay. You don't know where his phone is? Okay.
Oh, this is so rough.
She's asking about her car keys. She said we asked him, should we ask him right now? He doesn't have that progress, so. Okay. Where is she? She's up behind your vehicle. Yeah, do you want me to take now?
Yeah, she doesn't pay for the apartment. The ex does. Yeah, that alimony goes a long way.
No, he didn't have anything to find. We can take a picture real quick, you don't mind? We're gonna take one little girl. Okay, you want? Stay right there. Actually, a little more this way, so we don't get the police car.
You said what?
Pictures. God, if I was to wake up in the middle of the night to this, I'd be pissed.
He didn't have anything in his pockets.
She's more worried about her keys.
I'm gonna go on the sidewalk.
Yeah, no, absolutely.
Her and her fake God blessed tears.
Mm-hmm.
Yeah, if my wife ever pulled any crap like this, I'd be gone. Like, there would be no coming back from it.
Yeah, it would happen one time and that'd be it. That'd be done.
I'd be like, done.
Yeah.
Yeah, there's no playing with that kind of crap right there.
Mm-hmm. Yeah.
So rough, man.
Yeah.
So rough.
They're gonna be coming this way, so if you want.
All right, I'm going to skip over that.
That's it for that exhibit. The state is at the pleasure of the court and the jury if we want to proceed.
Can the parties approach for a moment?
That was
because
that
there's
was, those
one
are her
part in here
letters.
that I heard earlier that I picked up on in a statement that she makes that is really telling, really telling. And the thing is, the judge already made apparently a determination. Well, the state brought it up too, if I remember right. I don't think I heard it from the judge, but the state brought it up at one point when they're talking about, and the jury will be able to review video in the jury room. So they can go back, and so they may take a lot longer than what we may think, because they may be playing back some of these videos. But that was what the prosecution had made a statement on at one point in here. And so I hope they either heard it at this point or that they catch it there, because there's one statement that I picked up on earlier that was very telling that she made. Very telling.
She's here reading her letters that she wrote to the judge.
Members of the jury, thank you so much for your attention this afternoon. The state still has some additional evidence to place into evidence. It's about an hour or so. Now, I know I got a note this morning, we can't stay past 5:30. So the question I have for y'all is, are you okay with staying until 5:30? Or do you want to go ahead and call it an evening at this point in time? I leave it to you. It's 5 o'clock. 5:03, exactly.
So do you guys want to continue on, or do you want to cut it off tonight and watch the rest of this tomorrow morning? What's your choice, people? What would it be? Should I run a poll?
I say, well,
I mean, it's 11 o'clock. I can go. I got it. I got this.
I don't think it's that much longer, if I remember right.
Yeah, it's not.
Yeah.
There's. Yeah.
It's not that
we
much
got this.
longer.
Yeah, we got this.
I say keep going. Does anyone reject?
There we go.
First file being published.
And then I just saw one of Aliquod's questions.
What was
why
that?
Well, up here where it says, she asks, and why can't they ever turn lights on in the house? So like when they're doing a search like that, part of that is because when you're going through and doing a search and you're doing a clearing, lights are already off. You're using your flashlight, and part of that is to disorient the individual. They're already in a dark environment. So when you're going through and doing a search like that, you're using your flashlight as part of their distraction, part of basically like blinding them. And if you start flipping on all the lights, it silhouettes you as well.
Yeah.
So that light helps to not only blind them or disorient them, but keeps you from being silhouetted.
Right. And also your eyes have already adjusted to it where their eyes haven't. Yeah. Yeah.
Is img_0665.mov.
Oh.
Whenever you leave the house, just let me know where you're going.
Oh, after. Oh.
And you're gonna let me leave.
Yes. Just let me know where you're going.
And I get to leave the house.
Yes.
Exit.
Just let me know where you're going, so at least I know where you're at.
Anything else you'd like to add?
I love you.
So it's not yank me back in the house and sit the fuck down and shut the fuck up?
No.
Yank.
No. Just let me know where you're going, so I know where you're at. So if you don't come back, there's no certain time. You don't have to come home at a certain time, because I'm not. You're grown up. I just want to know that if it does surpass a certain time, that's like, shit, where's she at? I know where you told me you were going to be at. So that way I can go and.
So I'm not allowed to have friends.
Yes, nobody said you can't.
That's not what he said at all. He was. I understand what he's saying. This is so bad because he's been drinking. But what he's trying to say is like, if you're going to be out all night, at least let me know where you're going so I know where to look for you. If you're not home in the morning, at least I can go and track you down.
But see, this goes
drunk ass home.
And this right here goes along with what we were hearing about before when I brought up the telephone thing. She's always guiding the conversation. She's directing him what to say. And in this case, and subsequent there too, she's videotaping it, telling him, and then he's repeating So this is a dude that is just beat the fuck down.
This is
a guy that is just trying to go along
shit.
because in his mind, he's got nowhere else to go. And again, I don't know what his relationship with his family is or how close they were to him, but it sounds like his brother cared about him, or at least had contact with him.
Right.
But apparently he didn't feel that he could go there or whatever. So he's just trying to comply. Okay, yeah, fine. I'll say whatever you want me to say. This is a guy that's just beat the fuck down. She is the abuser. She is the manipulator in this. She is by no means an innocent angel in any of this at all. Battered wife syndrome, my ass.
Nah, I think that's a little more of Puerto Rican. I think he's Puerto Rican. I could be wrong. Puerto Rican.
I have friends.
I can go see Boo.
You can go see whoever. I just don't want you to go frolicking with male friends.
That's reasonable.
By yourself, because you know what's happened already.
So she's already cheated on him multiple times.
You understand what I'm saying?
So I get to go see Boo.
Do you get what I'm saying?
I get to go see Boo.
I don't care about Boo. You can go to see Boo. Do you understand what I'm saying, though?
Yeah, she was cheating on him.
Mm-hmm.
He was hoeing it out, throwing it out there.
Next video is
Looking
a
for the next one.
long file name that starts with 2A494, and it's the only one that will show up with that search.
Yeah, she's the
Date
problem.
modified indicates
I'm getting that
12/29/19,
vibe myself.
12/26. Yeah.
I hope that expert witness for the defense, that supposed expert pseudoscience witness of theirs, feels like a total dumbass after seeing these videos.
Yeah. He's
I hope she
recording her.
feels like shit.
Yeah.
Let's just tell everybody you got crumpled on the bed.
Crumpled? Crumpled. The word you're using is crumpled? Alright, so this is my she's you gotta put it off of my face, dude. I know you're filming me, but you gotta put it off. The fuck is that? Stop.
Bum rushed.
Yeah, you bum.
I bum rushed you.
Yeah, whatever. Anyways.
What was the choice?
So the choice was to beat your ass or get my ass beat or whatever.
No.
Huh?
Twas.
Huh?
Twas.
Twat?
Twas.
I like twat. I've been trying to get twat from this woman.
That's drunk talk. This is why I don't drink
part
heavily
was
on
funny.
stream. Yeah, that was.
I've been trying to get twat from you for a while now. Yeah, because she's giving up to everybody else.
Yeah.
I've been trying to get some of that right there. I'm some of the shit. I don't know what's going on. She's trying to film me, filming her, and blah, blah, blah.
I'm calling you.
No, yeah, you are.
Damn right.
You are cool. You are cool.
We live for it.
She is cool with me. She is beyond cool with me.
Oh,
One
I
point he
want
had
to
a
get
phone.
some tape.
Can I take you stairs tonight?
No.
Can I take you stairs to the beach?
No.
But who was my mom?
You. I blame it on you. Sorry. I apologize. Can I walk around this way and actually film it better? I don't want darkness because you're not dark. Ooh, there she goes. There she goes. What are you filming? You filming me filming you?
What do you want to bet? She's nude right now.
You filming me filming you?
Oh, come on, man.
Serious?
What's the next thing you've done me wrong by?
Man, I watch porno.
Yep, she's nude right now.
Wait.
Yeah, it makes sense based on what I said. I'm gonna have to drill out my head.
He's filming her.
All right.
I'm
drilling out my head again.
She don't like that. I'm not showing my shoulders or anything like that lately. It's not a big deal.
After you begged and pled and cried.
Yeah.
We tricked you.
I'm not showing my.
Say it. Begged,
Yeah.
pled, cried.
You begged.
I didn't. You did.
Well, whatever. Okay, yeah, I did.
Just jumpstart you.
Say it.
I begged and
Pled. And cried. For me to trust you.
For you to trust me. But again, I'm not
Did
sure.
you?
Did I watch porn again? Yes, I did. But
good.
Having trouble typing. She's like, did you watch porn?
I know, Tracy. It's all right.
Next is a video starting with 3BB0C. Metadata shows date modified 12/29, 12/36
Tell them what to
p.m.
do
of
and say.
2019.
Yep.
Yeah. So you remember this. Are you drunk right now?
no,
How much alcohol did you drink?
enough. You drunk?
You're slurring your words. You're sleeping up against the door right now.
Yeah, because I want to be next to you.
Did I not tell you to not bother me?
Yes, man.
Oh, dude.
Yeah.
So she made him sleep in another room, probably downstairs on the couch. And he just was like, I just want to be next to you.
Yeah.
Oh, fuck.
So what is it you come up and do? What time is it right now? It's 1:20 a.m.
I haven't bothered you since then. I just go to sleep.
But didn't I tell you before at 9:30 to not bother me at all?
Yes.
Because why?
Yeah, tomorrow.
No. Because I've been up since 4 a.m.
Yeah,
since
outside the
yesterday
bedroom.
when you fucked with me.
Yeah.
Yeah, why can't you watch porn? Less work for you. Yeah, this is the guy she says we were two souls together. Yeah. This is her controlling you.
That's what I'm willing to bet by the way that he is acting. Okay. So apparently she told him early around 9:30 or whatever it was, I'm going to go to bed. I don't want you to bug me, blah, 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 blah. So this, in my opinion, because we don't see what's going on before this. So in my opinion, this is as close as he could get to her. So he's sleeping on the floor in the hall because that's as close as he could get. And she's in that bedroom just stewing shit over in her head and wanting to create an issue. So she goes barging out into the hall and wakes his ass up and starts this shit.
Yep.
It wasn't like he had busted in the door and was jumping all over her. My guess is that he was asleep in the hall and she woke him up and started this shit.
Yeah.
Just to start shit.
Or it's a possibility they had an argument and she locked the door and he just fell asleep. It was like,
right. It could that could be too. Either way, he's out in the hall, was asleep. You can tell by the way he's acting.
Yeah.
And she went out there and started filming, or started this shit and then started filming, because we don't see what's going on before this.
Mm-hmm. I see a pattern of humiliation rituals that recklessly
She
went
is the manipulator and the abuser in this. 100%.
Yeah, I'm feeling you.
100%.
I know how much vodka was in that bottle. And what's the bottle now?
No, she's not afraid of him. No.
Kind of to throw down.
What does that mean?
When we drink.
The bottle's empty. I know how much vodka was in there. Enough for two people to have a really good time. And who drank it?
Yeah, he probably did.
I want it to be documented that I'm leaving you, which means that you're getting out. You're getting out. You're getting out.
Nobody's leaving nobody. Stop.
And seeing how he keeps curling up and scooting away. I mean, she might as well be beating him with a rolled up newspaper right now.
And the reason why you were even downstairs and weak enough to get drunk was because you don't give a shit about me. You don't listen to what I say. Special things that I keep on
Welcome,
my
Winning Raiders. Welcome, welcome.
front page of my phone, so I remember to tell you about it because of how special and fun it is.
Thank you.
I always bother you.
buddy.
I always bore you. You don't listen to me. Yesterday was my first day at work, remember? And I ended up 90% hearing about your day and
Kelly.
10% about mine.
How you doing?
How you doing, girl?
So sometimes you just you overwhelm me. That's the problem. You overwhelm me.
I tell you about my first day at work.
No, dude, you just overwhelm me about every other thing too. Just first day at work.
So I'm overwhelming you by telling you about the fourth highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So
That's
the
a good
reason
one,
why,
Heidi.
so
That's a
you
good
fully
one.
admit now that you didn't care and you did brush me off in the car. Midway sentence,
Hey, T-Rex.
because you're not into baseball.
What's up,
Good,
Winnie?
Heidi.
No, I'm saying.
I want to go to sleep. Go downstairs.
All right.
I'm leaving you, and I'm going to try and cancel plane tickets.
No.
Because I don't do special things for people like you that are doing this. Like, to me, after I asked you at 1:21 in the morning, I wanted to be asleep. I wanted to stay asleep, which is why I got into bed at 8:30. I told you not to step foot in the bedroom. So what do? Nonetheless, you're drunk. The amount of alcohol, I know how much was up. I know how much was in there.
Wow.
That's why I could smell you in your bed before you actually got me up.
Well, that's part of it, Lulu. She's
can
the
smell
aggressor
you
in this. She
from
just
here.
beats him down.
Yeah.
Verbally beats him down. Over and over again. Which is why he's acting the way that he is.
Yeah.
You're despicable.
I'm not despicable. I'm not even doing anything.
Leave me alone.
Okay.
Okay, I'm trying to sleep.
You're not gonna remember shit. Okay.
Yeah, okay. Well, I'm not doing nothing right now.
Get away from me.
Get away from me.
Get away from me.
I'm right here. Oh, Jesus, man.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
Okay.
Keep going. And I dare you. I dare you. I dare you. You get on your fucking little bike and go to fucking work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out, get the fuck out of here. I dare you. Yep, look at it. Like, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder.
Wow.
Get away from me.
He was
I'm gonna fucking
asleep,
hurt
but
you.
she just came at him.
And you're filming it.
Let me go. I'm asking you, George, to get away from me. Please get away from me.
Wow.
Get away from me.
Yeah, I am.
Push.
That was your function, dude. Malfunction.
Well, that's
No,
the whole
your
thing.
malfunction is you, dude.
Okay,
That's
whatever
what
you
she was
say.
wanting.
Whatever you say.
Because he turned around and started to go downstairs, and every time he turned around to go leave, she just fucking stick him again and stick him again. And, you know, I'm not saying that he was right in coming back up the stairs at her like that. He should have just kept going. But that's what she wants every
First it's
fucking
shit,
time.
now it's alcohol.
And now she's following him, yelling at
Right,
him,
exactly. Yep.
talking to him,
Yeah.
pushing
She's
him.
not afraid
pushing
of him
Push the
at
button.
all.
She is not afraid of him at all.
Don't step foot in this bedroom. I can't even breathe. Like, it's disgusting. Like, it's disgusting.
Here she comes.
Mm-hmm.
Keep filming when it's looking like. Good night, Sarah. Love you.
I don't love you. I don't like you. I don't want to be with you.
Yep, I would have packed my shit and been gone a long time ago. Never would have let that shit happen.
Well, and that's part of the thing. If anybody there that I'm seeing has an abuse syndrome, it's him.
Yeah.
It's very classic. Whether male or female, they get caught in these situations where they see no other way out, and so they just fucking take it and take it and take it and take it.
Well,
and I'm not saying that he's a perfect guy, and you and I
No.
can, you know, look at this from a different perspective and say, yeah, fuck this, I'm out of here.
Yeah.
And that would be it. But some people, when they get caught in that vicious cycle, it's hard for them to break out of it.
And they don't realize they're even in it.
Exactly. You're standing too close to the flames to see the fire.
Yeah. Wow.
And it ended up ending him. And that happens on both sides frequently. We see it all the time.
Yeah.
I mean, it's not a new phenomenon, but
Yeah, amazing how similar it is to Depp Heard. Yeah. Because whenever it's good between them.
Right.
Like whenever they're having a good time, it's good.
Next video starts 456. That's the only file that starts with that. Date modified metadata, 12/29/2019, 4:04 p.m.
And I'm not going to have no Hindenburg situation, no Titanic situation, okay? So it's going to be a good day. Yes, I'm missing my mustache right now. And later on, everything's going to go off. Truth, facts. Truth and facts. All of this is going to be mentioned later on. We'll take another video again later on when it happens. Love y'all whoever watching this video.
No, that's not approved.
The FDA says it's approved.
So it's going to be a good day all day.
Yes, it is. Even when
All
I
day.
shave all of this
All
off.
day.
Yes. Even when I shave all of this off.
All day.
It's going to be an amazing day.
It's what time right now?
Shaboing
I
boing.
would say 9:30. 7 o'clock maybe.
Shaboing boing. That's what we're doing later on. Shaboing boing. Titanic situation, okay? So it's going to be a good day. Yes, I'm
Closed
missing my
captions.
mustache right now. And later on, everything's gonna go off. Truth, facts. Truth and facts. All of this is gonna be mentioned later on. We'll take another video again later on when it happens. Love y'all where we're watching this video.
No, that's not approved.
The FDA says it's approved.
So it's gonna be a good thing all day.
Yes, it is. Even when
All day.
I shave all of this
All
off.
day.
Yes. Even when I shave all of this off.
All day.
It's gonna be an amazing day.
Sarah
It's what
Boone
time right now?
see you
Shaboing
next
Boing at
Tuesday.
9:30. 7 o'clock maybe.
Business too good for
Shaboing Boing. That's what we're doing later on. Shaboing Boing.
Yeah.
You can stop filming now.
Not good enough.
It's gonna be a great day. Today's a great day to have a great day.
Nice.
Boom. Cut. Somebody come in with a. Can somebody come in with a? Can you not?
Damn.
Next file is image underscore
Yeah, and
093
Shelley's got a
.mov.
point. There will
Metadata
be
date
something
modified
you can grow up
1
with,
3 2020 2:48 p.m.
It's switch 13 and I asked him not to play with it. Because I told him that I'm just gonna go to shit.
Calling his music shit. And he's like, just looks at her and is like,
Next
fuck
file
you.
is image img underscore 0975.mov. Metadata shows date modified January 19th 2020 2:58 p.m.
Constantly be
Time.
Mm-hmm.
Hey there. You have a good one. Kezzy, she already did.
Sirens. And this cop car.
How about you get an umbrella and call me Camille underneath it?
Yeah, how about we forget about that? No.
I'll never be.
How about we keep going on?
No, she was talking about something else. She is.
Oh, okay.
Okay. How about this? When beautiful Lucas is here, we don't listen to none of that. I don't want to hear sirens. It's just beep, 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 all that. Whatever.
Ah.
I don't want to listen to that. It's every single day. Beeping and we hear enough of it out here in reality.
Are you gonna be nice tonight?
Yes. Yes. I promise you. I just
go for a walk.
By myself?
Yes.
No.
Go for a walk.
I'm just gonna chill out. If that's the case, I'll just chill out.
Wow.
So much like this.
Don't ever be a woman.
What are you talking about? What?
How can I be a woman?
Don't ever.
I can't. But I can somewhat understand.
Don't ever.
I can somewhat understand. Somewhat understand. I can somewhat understand, yes, where you're coming from.
That is drunk babble 101
But
right
when you
there.
have a child, and it's like right now, this is too much. But we had a blast with them. Amazing.
Then you got out of sorts and pushed me, and he stole my phone and called Greg.
Ugh.
Why is it that I got?
You pushed me.
I pushed. I didn't push. How do I get out of sorts all of a sudden? I don't want to hear it.
Oh, your dumbass is probably drunk and fell down again.
Go get your fucktard shit.
What are you talking about?
Your retard paper.
Wow.
Don't hit women.
Have I hit you? No. So where are you going with this?
Does she ever feel not drunk?
Tell me whatever else you have off.
The only time she's got.
You can
all the
film
time.
me, take a picture of whatever you want.
You can tell you're automatically
I'm not
drunk.
doing
Do I ever get a bite? No, I don't.
I'm not doing anything to you.
No, I never do.
I'm not doing anything to you. Sarah.
Yeah, she's absolutely
That's
terrified.
my name. Don't wear it out.
Sarita.
Yep.
I'm not doing anything.
Always in fear for her life. You can tell.
Yeah.
Yep.
It's not yet. I will not.
Wow.
Mr. J.
It is 5:28 and we have 3 minutes and 49 seconds of videos. Jury is capable of staying.
I got a thumbs up from the jury. You may proceed, sir.
Okay.
Next image.
Yeah,
IMG
they bought into this now. They want to see this out because they got
Metadata
all
shows
night
date
to think
modified
about it.
2020, 11:42 p.m.
They want to see who the aggressor really is.
Hi, my fan. This is what happens. Are you going upstairs to ask for my car keys, are? Because it takes a little time.
Can't really comprehend it, but it's
Where
worse.
are my car
Yeah, I can't
keys?
comprehend what they're saying. It's asleep.
Where are my car keys?
You got drunk and lost him again.
Where are my car keys?
Where are you going? What are you talking about?
No, they're not. You took them.
What?
Sarah, I didn't see your car keys. Anyway,
Where are my car keys?
where you at? All the time. What in the world are you talking about? They're in the. They're there with it.
No, they're not.
Sarah. Correct the.
No, they're not. You took them. And watch you walk away with them.
Just imagine.
Jesus.
Just imagine this is the time.
Yeah.
That she comes up there and he's laying in bed, asleep. Where's my car keys?
Yep.
Grabs
Over
a baseball
and
bat.
over and over again.
Grabs a baseball bat, hits him. Stuffs him in the suitcase. He starts to come to, hits him again. Starts to come to, hits him again. Zips him up in that suitcase, drags his happy ass down the stairs. Dum, 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 dum.
Oh, I'm thoroughly convinced she didn't drag him. She pushed him to the edge. Because I'm thoroughly convinced that this shit started upstairs.
Yeah.
And then from my initial thought, and then having gone back and actually listened to the ME, it makes total sense. Some of those marks on his back and the back of his arms and on the sides of his head. Because he had no broken bones, which was really surprising to me. And she louged his ass down the fucking stairs. And so then as he rounded that corner, as I brought that up the other night, as he rounded the corner at the bottom of the stairs and she completed to push him down there, that's how it flipped over on its lid. When it hit the bottom. That's how it plays out in my mind.
And I'm probably wrong. So.
Why would I take your freaking car keys?
Oh, you're not going to curse now?
What are you talking about?
You took my car keys.
I didn't take your car keys.
You did.
She did? I thought it was bad. I mean, I thought it was bad. I just didn't think it was this bad. Good God.
Yeah.
Movie starting with file name B51, long file name. Metadata shows 12/29/2019, 4:04 p.m. modified.
Drunk or passed out. Yeah, possibly. I think that's his mom's house.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and got out of hand. Isolated situation, it has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving.
I'm just, oh my fucking God.
This part right here in this video in
Her
particular,
testimony.
Well, it reminds me of a terrorist video where they're sitting there telling them what to fucking say right before they off them.
Yeah.
That's what this reminds me of.
That was her testimony too. I had 2 dogs, but one was blind, one was deaf, and I brought him in, and I had my 7-year-old son, or he's 14 now. This is almost identical to her testimony. Oh my fucking God.
And sees an animal that's injured, she'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other, we both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially.
Especially her.
Jeez.
So please, if you can,
Dismiss
this case.
Closed.
Drop it. She is not that type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. I love you to death. And I hate that we're going through this.
Wow.
Sonic.
What?
And they did.
Good, I love you. God will prevail and will take us out of this situation.
Thank you.
That'll be it for today, Judge.
All right. Get your noise back up.
Okay, so I must have missed that one part, but I picked it up earlier.
Members,
there's one of those when they were arresting him, and right before they take him out, and they're standing there in the dark, I could clearly hear her say, "I will not hesitate." There's something about being arrested, blah, 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 the police showing up, and she clearly made that statement, "I will not hesitate." That right there is a very telling statement. That this is a lying bitch who is not afraid of this guy and was an instigator for everything.
Yep. Yeah, it was that first.
She was never in
interaction where he
fear.
was-
No.
Yeah, it was this interaction right here at the very end.
It's one of those, yeah. I think they were still inside the house.
Yeah. One dog's sleeping downstairs and one's in your bedroom.
Coming from the area. Someone else in her.
Yeah, we'll have to review it, but that's the one where it is. Wow. Just wow.
Members of the jury, it is 5:33 p.m. I thank you again for your time and your service in this matter. I'm going to give you another instruction before I discharge you for the evening. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk.
That's why she keeps smiling at the ladies. That's why she keeps smiling over at the jury.
Oh, is that what the jury's made up of? Five females and one male?
One male on the jury. Do you think? And that is why she's over there smiling to him. They don't realize how evil. She does not realize how evil women are. Women can be very damned evil.
Well, and that's what I was saying earlier. Between the two, between dealing with males or females, I was always much more hypervigilant with females because they go off just like that. On guys, most of the time, you could see it coming. You could see them winding up. You could be prepared for it. But with females, they'll flip on a fucking dime, and then they'll be crawling all over you like a wildcat.
Yeah.
I was much more careful around women.
Whereas men, they start working up to it. They start working up to it. They start working up to it, and you're just like, oh shit, there he's about to go.
You can
off.
see it coming.
He's about to blow, and you're doing everything you can to tone it down and bring it down. With women, everything is cool. They're chill, and then all of a sudden,
they're fucking crawling all over you, and you're like, what the fuck just happened? Yeah, they just go sideways real quick. Yep. Yeah.
So it says there's one of the guys is in his 50s. There's one of the 50s, a note taker. I don't know.
Talk about this case face to face. You must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we'll see you again tomorrow morning here at 9 a.m.
That was a good way to leave that jury.
Oh yeah, and I think the defense is pissed about this. They were not wanting this.
Nope.
They were not wanting
they
this.
Opened the door.
All.
They opened the door to it.
Yeah. Yep.
Y'all take a seat. Bruce. Thank you. Y'all can take a seat. Thank you.
I got to slow this down because I don't want to speed past what he's going to say.
State, how much additional presentation do we anticipate tomorrow, sir?
It is just reading from the 108-page PDF that was on that last exhibit. I haven't practiced reading it in front of the mirror, so I'm not too sure, but not too long.
Okay. 40? Okay. All right. And then you'll be resting at that point in time, correct?
Yes, sir.
All right.
Look
Defense,
at Mr. Owens walked away.
what, if any, positions do you have at this point in time?
He's just like, fuck, we're so screwed. Oh, sorry.
Yeah, he looks.
I don't think we're going to put on the server bubble. But
He looks and sounds defeated right there.
Okay.
but I anticipate no.
Okay. I'll certainly let you stew on it this evening. I know it's been a long day for all of us. Where are we and how do we want to address the jury instructions? Because that is going to take some time.
I say, I was thinking we should have had the jury go to 10. Trying to take care of that ahead of time.
Well, the other alternative that I can suggest is I can be here at 8. I can get here at 8 and we can start working on jury instructions at that point in time, at least so we can move forward through some of it. And then we can try to just move forward from there.
Tomorrow's going to be a shit show with Owens.
I'm here for y'all. You tell me what you want.
Interesting. Very interesting.
Starting charge conference at 8.
I mean, my worry is it's going to take us some time. And if we start at 9:40, and it's going to take some time to work our way through these jury instructions. I don't want them sitting back there for 2+ hours just hanging out. We can at least get ahead of that.
1 hour would be fine, but 2 hours sitting back there, you show up at 9. Oh.
Yeah.
It's going to take longer than 2 hours.
Yeah, I would have told the jury not to show up till
to
10. I would have told the jury not to show up till 10, make them be there.
I would have told them noon. I would have told them to be there.
Well,
at noon.
maybe even noon. Who knows? But at least 10.
I guarantee you that jury's going to be sitting there until noon.
They're going to be sitting there a while. But going to D. Robertson, so did the defense not see these videos before? No, they would have seen these.
Oh,
but,
yeah.
But in their minds, they were twisting it around. I don't think the totality of it has really dawned on them until today in court.
Right.
When they were going through and showing all this stuff, and you could see how people would come to the conclusions that we've come to.
Yeah.
I just don't think they thought of it that way.
No. They thought of it as she was being...
They thought of it as, oh, they're going to see him
herself.
getting arrested over and over again. Oh, he's breaking the restraining order. He's, doing this. He's doing that. Oh, yeah. This is going to go to her defense. But all we're seeing time and time again, the middle of the night, her waking him up, the police waking him up, him being arrested. Oh, come back. Even though you got a restraining order, don't worry about it, baby. We'll make everything okay. It'll be fine, blah, blah, blah. And leading it back into these traps over and over again.
Yeah.
They didn't think that it was going to have this cascading effect.
No. And I guarantee you they're looking at that jury whenever that jury was just like, no, give us all of it.
Mm-hmm.
Because they're going to go home and they're going to be
stewing
playing
on
through
it
the
all night long. Yep.
Oh, it shows him drunk, being abusive, shows him breaking restraining orders, being arrested by cops. Yeah, this is going to be good. And what it shows is a man.
And her going after him,
Yeah.
even as he's trying to walk away, or just following him in general, sitting that close to him, but yet she's so afraid of him. She's always in fear. The fuck out of here.
Yeah. Shows complete opposite.
Mm-hmm.
Oh my God. You have to be blind not to see that she was the aggressor. I think Sarah demanded this trial be run this way. She got her dream trial. Yeah. Because she thinks she's justified in all of this.
Oh yeah.
In her mind, she feels completely justified in every single bit of this. And I would bet that this is the same thing that all of her other attorneys saw. And they were just like, Sarah, you've got to take a plea deal. And she's like, he is the aggressor. He is the one doing this to me. How dare you? How dare you accuse me of being the aggressor? I'm not the aggressor here. It is me against the world. It's always been me against the world.
Yep.
Oh, no. I don't know. I don't know anything about George.
And if they don't lock her out, if they find her not guilty for whatever reason.
Yeah. I
guarantee
surprised.
I guarantee you that she's going to be back in a courtroom for something like this. If she's not the one that winds up deceased.
Yeah.
Guaranteed. And even if she does go to, say she goes to, I can't remember how old she is. So say she gets 20, 25 years, if that's, whatever they're looking at for this. If they get her for the second degree. Who knows? It may go down to manslaughter, which would be less.
Yeah.
It still wouldn't surprise me if when she gets out, I highly doubt she's going to learn a lesson. I highly doubt she's going to change. At this age and all the shit that she's done, Tiger doesn't just change its stripes. So when she gets out, she's going to be one to watch. Yep. Yeah, exactly. Next time we might not even have a body to find.
No, the lawyers have to fight for her to tooth and nail.
I could fix her. You're out of your mind. I wouldn't touch her with your dick and shizzy pushing. Oh, I'm sorry. Probably shouldn't have said that.
No, that was pretty funny. It's been 4.5 hours. It's been 4.5 hours. I want to see what the rest he says.
You're still here. I'm fine with that. Stay.
You want to stay late?
They're gone. Okay.
What I'm hearing is maybe closing argument start at 1.
Yeah, that's possible. That's possible.
What did I tell you? He's expecting noon. He is going to push it till noon.
Oh yeah. Oh yeah. He's going to create havoc tomorrow. He's going to argue on every freaking little thing, guaranteed, and it's just going to get dragged out.
Yep.
He's going to try and drag this as long as he can.
Yep.
Every little thing. Because we saw it earlier. Him and his bullshit attempts at trying to get a mistrial.
Yep.
And prosecutorial misconduct.
Oh, God.
And at one point, I thought for sure that he was going to try and accuse the judge and go for judicial misconduct.
Yeah.
That wouldn't have surprised me at all.
No.
This guy's trying to pull all the rabbits out of his hat, and the problem is they're already dead.
She's. This is why tiny little Sarah is not scared.
Yeah.
She's got a mean streak that and I mean I've seen women like this.
Mm-hmm.
I'm so happy that I've avoided this crap. Like,
yeah.
After seeing this shit, I'm just like, oh my God.
Yeah.
My God. Just I can't imagine all the guys in the world that get they're just like you know what, the pussy's so good, I can't live without her, she's my everything, and they're going through the same shit.
Mm-hmm.
Oh.
Well, and that's part of the thing too for somebody that's probably never really. I mean, I can't remember. I thought he came from Venezuela or something. But anyway, outside of that,
no,
really,
he's
but
he's
for
got
people
two
that have never
ex-wives,
been,
he has kids.
Well, right, but for somebody who, but like Shelley was saying earlier, this could very well be a pattern with him. Who knows what his home life was
Other
like.
ones are, yeah,
his
true.
mother, his grandmother, especially being in that type of
family dynamic.
What do I want to say? Yeah, family dynamic, societal dynamic, whatever, especially with Hispanics. Italians seem to be a lot like that as well, where they just deal with that kind of shit. They have a tendency to have overbearing mothers and grandmothers, and that's just kind of unfortunately the way the thing is. So that could very well be how he grew up. So but my point is that having been all over the world a couple times now, there ain't no pussy worth this. I can tell you that right now.
Nope.
It's not worth it.
No, not at all. God.
I don't care if she's fucking queefing gold bars. It's not worth it.
Well, at least get a couple of them and get the hell out.
Well, yeah, snatch a couple of those gold bars, but then get the fuck out. Got to play coyote. You got to play coyote. I mean,
this is still one
you
of my
may be one arm short, but
this is still one of my favorite pictures.
Yeah, that thing is just so weird, man. That's just so creepy.
Oh my God, it won't go away. Stop. Why won't it go away? What happened? Here we go. We're ending this thing.
Look inside, I curl and wait. You passed out, hoping you return my fate. Empty my stash out. Stupid game has turned too cruel. Are you feeling me? Love is gotta feel the fool. I can breathe. Wasn't meant to be my night. Hiding in the suitcase tight. Sarah's giggles fade away, leaving me as a castaway. Sarah, let me out. I'm begging, please. And please, breathing stuff. I'm almost begging. Please, grace gone wrong. Don't leave me here. Lost my air in this gear. In this case, I disappear.